Morning. Good morning. Good morning, day 2 of the Joint Revenue Committee meeting in beautiful Lander, Wyoming. And so if we could please call the roll.
Senator Baldwin. Here. Senator James.
Here.
Senator Pappas.
Here.
Senator Schuler.
Here.
Representative Baker.
Here.
Representative Gray.
Here.
Representative Hallinan.
Excused.
Representative Henderson.
Here.
Representative Jennings. Representative Roscoe.
Here.
Representative Sweeney.
Here.
Representative Yin.
Here.
Co-chairman Case
Present.
and co-chairman Harshman.
Here, thank you.
And we have a quorum, Mr. Chairman.
Okay, thank you. Thank you, Mr. Anderson. Okay, members, we've got these 2 topics today. And then the idea would be to, if there's anything from yesterday that we need to work on, and then directives to the committee final before we break. So how long that depends, we got it scheduled to about noon or 1, we'll see, and go from there. So appreciate everybody's attendance today. First item on our agenda this morning is tobacco taxes. And Mr. Anderson with LSO has got a primer for us, a little history. So I'll turn it over to you. Thank you. And just by the way, I just tell you, our LSO staff, I really, before the day gets away from us, that whole thing yesterday was incredible. I know you were all in on that. Appreciate all your work and getting us ready. And this is a beautiful place to have a meeting too. Your old junior high.
This is the lunchroom.
I could sense that. And so we're appreciative of Fremont County District 1. It's a great place to hold a meeting. So anyway, appreciate our staff getting us all set up. First meeting or one of the first out of the chute here to start the interim. So, okay, Josh, floor is yours.
Sure thing. Thank you, Mr. Chairman. Josh Anderson, LSO. One of our topics signed by Management Council is a review of tobacco taxes. So just put together a real brief kind of white paper for you guys on the history of tobacco taxes, specifically the tobacco tax rates as they've come in through Wyoming history. And then you'll see a comparison with some of the surrounding states just to kind of start the discussion. So, Mr. Chairman, you'll see 1951 is when the tax on cigarettes was added. It was 1 mil per cigarette, which worked out to 2 cents per pack. In 57, that was increased to 1.5 mils or 3 cents per pack. And then again in 59, that was up to 2 mils or 4 cents. And then in 67, 4 mils or 8 cents a pack. In 1989, and again, that was taken up to 0.6 cents or 12 cents per pack. In 99, the tax on cigars, snuff, and other tobacco products was added at a rate of 20% of the wholesale price or 10% of retail. And that is the current rate today. So that rate hasn't changed since that time. In 2003, the cigarette tax was increased to add an additional 2 4/10 cents or 3/10 total, 3 cents total per cigarette. And that works out to 60 cents a pack. And that's where we are today on that, Mr. Chairman. 2009, moist snuff was split out from the other tobacco category at a rate of 60 cents for any amount up to 1 ounce, and then an additional 60 cents per ounce after that. In 2019, the cigarette tax was reorganized. That rate didn't change, but just changed to specify that it was 3 cents per cigarette or 60 cents per pack of 20. And then in 2020, this committee added the tax on electronic cigarettes and vapor material at 15% of the wholesale price. The current distribution, Mr. Chairman, is of cigarettes goes 85% general fund and 15% to local governments. Revenues from cigars, snuff, other tobacco products, moist snuff, and electronic cigarettes is all distributed to the general fund. I would note here, and something this committee could consider looking at, the distribution of the tax on moist snuff is not actually specified in statute. When it was split off from the other tobacco products, the distribution wasn't adjusted at that time, Mr. Chairman. So for amounts in 2021 from the Department of Revenue report, the cigarette tax generated $13 million to the general fund and about 2.3 million to local governments. And then other tobacco generated about 6.2 million to the general fund. So some comparisons with surrounding states. You'll see in this, sometimes moist snuff is not specified. Some states just tax that along with all other tobacco products, as Wyoming used to do. So, Mr. Chairman, just running real quickly through this. Colorado cigarettes are $1.94 per pack, and other tobacco products are taxed at 50% of the manufacturer's price, and vapor is taxed at 35%. Most of the surrounding states don't specifically tax vapor, other than I believe Colorado and Utah. Idaho tax cigarettes at 57 cents per pack, just slightly less than Wyoming. Other tobacco products is taxed at 40%, and vapor not specifically taxed. Montana cigarettes are $1.70 per pack, moist snuff at 85 cents per ounce, other tobacco at 50%. Nebraska cigarettes are at 64 cents per pack, just slightly higher than Wyoming. Moist snuff at 44 cents per ounce, and other tobacco products at 20%, which is the same as Wyoming. South Dakota at $1.53 per pack, other tobacco products at 35%. And then Utah, $1.70 per pack of cigarettes, moist snuff at $1.83, and other tobacco products at 86%, and vapor at 56%. So that's what I had, Mr. Chairman. I'd take any questions.
Hey, members, any questions? So just looking, any questions? Just if you could recall, maybe just some of the discussion, where you recently taxed vapor and why that is different than cigars. I can't remember.
Mr. Chairman, I don't recall either. I think, it was similar, if you look at the two states that do tax vapor, they also did it at rates lower than their other tobacco products. So Colorado does 50% for other tobacco, but 35% for vapor. Utah does 86% for everything else, but 56% for vapor. I know New Mexico was similar in that, and I believe New Mexico is also lower than we are on vapor at around, I think, 12% or something like that. So I don't recall the reasoning for that, Mr. Chairman, but that does seem to be a trend.
Any other questions? Representative Sweet.
Thank you, Mr. Chairman. So in your look through, there in the surrounding states, a few of them have legalized either by ballot or on their own cannabis. Have any of those taxes been rolled into how cigarettes are treated, or is that totally a different subject matter?
Mr. Anderson.
Mr. Chairman, most of the data I looked at was from a national association of tobacco sellers. And so I think most states more highly regulate marijuana. So that wasn't included in this group's work. But yeah, it's generally, from what I can tell, treated separately than tobacco.
Thank you.
Okay, thank you very much. Okay. Part of this issue is this kind of tax on cigars, but is there any other items to present us? So we're going to open this to public comment then. Okay. Anybody here in the room would like to comment on this topic? I think we have a couple online, and I just wanted to, if anyone here. Okay, so we're going to move. We do have, come on up and introduce yourself and who you represent.
Thank you, Mr. Chairman and members of the committee. My name is Richard Garrett. I'm State Government Relations Director with the American Heart Association, and sure glad to be back in Lander. It's a beautiful day in a beautiful town. I'm going to be very brief. I think you probably all know the American Heart Association's position on tobacco taxes. I don't know what the committee's will be in terms of a potential tax or tax increase. But if you do consider a tax on cigarettes or an amendment to the existing tax, I'd urge you to make it a meaningful one, a tax that will deter young people in particular from adopting and taking up a habit that can impact their health for the rest of their lives. Our research shows us that a meaningful tax truly does have an impact on reducing tobacco consumption by teenagers in particular. I'd also like to share with you something that might seem a little improbable as I was researching this topic to try to help you in your consideration. It wasn't long ago that a catastrophic fire, believe it or not, happened in one of our western states because somebody discarded a cigarette. So there are unintended consequences too that can be very, very impactful. So it's an important issue, and I really appreciate you taking it up. It's a hard one, I know. Wyoming is 44th in the nation in terms of the tax burden on tobacco consumption. I think that we can improve our position considerably, and I appreciate your consideration. So with that, Mr. Chairman, I'd be glad to answer any questions.
Okay, thank you, Mr. Garrett. Appreciate it. Any questions? Okay, thank you for joining us. Okay, anyone else? Yeah, please.
Thank you, committee. Marguerite Herman. I'm here this morning on behalf of the League of Women Voters that has supported tobacco taxes, and as Mr. Garrett mentioned, meaningful cigarette tax increase to deter people from starting to smoke, especially adolescents, but also adults to cut down. And I confess it's been years since I looked up the numbers, but there's an argument to be made that aside from sending money to the general fund, which of course would decrease as smoking decreased, that would be the good news actually, but the real payoff is in adolescents who don't start to smoke. Again, lifelong addiction that has huge health impacts for Wyoming, but also a big impact on the public health costs to the state of Wyoming. So, I think the term is price elasticity. $1 increase per pack is what the American Cancer Society has supported, and that's where we are on that. We urge a tax that has a meaningful impact on initiation and continuation of use of tobacco. Wyoming has one of the lowest tax rates and one of the highest tobacco use rates in the country. So I think this would be a big step forward. Thank you.
Ms. Herman. Okay, thank you. Okay, anyone else here? Okay, we're going to move to online. Emily, if you could.
Mr. Chairman, we have Glenn Loop and Donovan Short online.
Perfect. Okay. Good morning. Who is going to go first?
Good morning. It's Donovan Short from Casper Cigar Company up here in Casper.
Good morning.
Morning. Our friends from PCA, and I think the CAA is represented today too, and also the folks on the committee are a lot more adept at the legislative sausage than I am here. So I'll be very brief so that those folks can weigh in on some possible solutions. But I think to help understand the problem from a Wyoming small business perspective, there's just a couple of quick points that might give you some context. Specialty cigar lounges, such as ourselves, we are a very small number in Wyoming. The bulk of the other tobacco products taxes, or OTP, are generated by hundreds of Wyoming retailers, from Walmart all the way down to your local convenience store. But there are literally a single-digit number of us in the state that focus on the larger cigars exclusively. And at our business, it is me and a single employee. And I don't exaggerate when I say that the Department of Revenue is the second biggest expense we have. Our product cost is number one, of course, but the DOR right now makes more from our efforts than either of us. Cigars are a point of passion for us. It's not just a commodity to us. And all that we are really seeking for the tax cap discussion on cigars here is a more level playing field on which to do business. We employ Wyoming people, we donate to Wyoming charities, we spend our profits in our local community, but like all small Main Street resellers, regardless of the product, we're also competing against large internet sellers. They do submit sales tax to Wyoming, but they aren't affected at all by OTP taxation that impacts the final price of the product, which does leave Wyoming small businesses at a competitive disadvantage. And the final point I would make is the method in which the OTP tax is collected. It's a big struggle for us on the smaller side. Unlike sales tax, which is collected upon the time of sale and then submitted monthly, the 20% OTP is collected quarterly for all the products that we purchase in advance of sale. And keep in mind, an average cigar order of something that sells well might take 90 to 120 days before it actually turns over and becomes revenue rather than an expense for us. And many take additional months to even a year or more before they're sold. We may end up clearancing them or selling them at break even or even a loss, which every quarter kind of creates a cash crunch for small businesses like ours that are already walking a bit of a tightrope like everybody else with inflation and supply chain issues, the aforementioned internet competition and more. With that, it means the world to us that the committee has allowed the conversation to begin. Thank you, Representative Gray, for bringing it to the table initially. And I will yield to our friends at PCA and CAA with some proposed solutions that have worked for other states. Appreciate it.
Okay, thank you, Mr. Short. First, any questions? Mr. Short? Okay, appreciate it. Okay, good morning.
Good morning, Mr. Chairman, members of the committee. My name is Glenn Loop. I'm Director of State Advocacy for the Premium Cigar Association back here in the swamp in downtown Washington, D.C. This is a unique opportunity to highlight a positive policy measure that has been embraced by 13 other states. Arkansas, Connecticut, Iowa, Michigan, Minnesota, Ohio, Oregon, Rhode Island, Vermont, Washington, and Wisconsin. Just recently adopted in the state of North Carolina. There's pending legislation to enact a tax cap in New York, New Jersey, and Nebraska. The benefits have been primarily in terms of not only just helping small businesses that would be less than 10 in the state of Wyoming, but the economic evidence right now, and this is somewhat anecdotal because this is a relatively new policy phenomenon, is that there's been an increase in state sales tax collections as a result of premium cigar, large cigar tax caps. That has certainly been the case, for example, in Minnesota and Michigan, which enacted caps. And in fact, Michigan just removed their sunset clause on their tax cap and made it a permanent standing part of their state tax policy. I think it's worthy to note that Representative Jim Nash of Minnesota's legislature and North Carolina State Senator Todd Johnson have both volunteered, and they told me I could convey this to the committee today, their willingness to testify before this committee about their positive experience in sponsoring such legislation in their respective states and the benefits it's provided to their respective businesses. Likewise, the Ohio Tax Department could attest to the positive experience of enacting a tax cap there. We have a study that's dated in 2014 that was done by another state, but I spoke to the economist that performed this study, and the methodology is applicable across the board to any state considering a tax cap. And it clearly demonstrates that there would be a positive benefit to the state in terms of sales tax collections, even if there's a nominal decrease in collections in OTP collections. And I'll provide that study to the members of the committee, the staff to the committee. In that regard, I think it's important to remember that, and this came to mind in listening to your staff present the overall tax picture on tobacco, is that premium cigars, large cigars, are a unique tobacco category. And in a way, it kind of clouds the picture that it's lumped in with smokeless and other tobacco products because they are unique. It's a very niche product and they're a more expensive product, which makes the tax on them all the more burdensome for small businesses like Casper Cigar Company. When you've got average prices per unit of $3 to $5, predominantly around the $8 area, and then you've got cigars that Casper and others are selling in the state of Wyoming that are well over $10, that's where the tax cap really comes into the ability to help steer that commerce to local small businesses instead of less expensive alternatives. I think in terms of and I want to make sure the committee notes this, that as we approach this type of a tax policy issue, it often gets clouded into the public health question. Cigar smokers, cigar consumers are a very discerning adult clientele. They're obviously an older demographic. The evidence is very clear, as sponsored by entities such as the Food and Drug Administration, that the questions of inhalation, addiction, and mortality are not equated with premium large handmade cigars the way they are with other products. The youth access question is a non-issue and has been statistically substantiated by the Centers for Disease Control. The infrequency of use, the average American cigar smoker consumes less than 2 cigars a week. That in and of itself speaks to the questions of things like addiction, inhalation, and mortality. So based upon that and the very price point of large cigars, we think that's the reason that a more specific, narrow, targeted tax policy is very much in order. And on the questions of the public health issues, I'd be glad to submit to the committee the evidence that's been presented to the Food and Drug Administration that clearly demonstrates the points that I articulated on the public health questions. So with that, likewise, I'd be glad to take any questions and hope that this is beneficial in your deliberations.
Okay, thank you. Any questions, members of the committee? Representative Gray.
Thank you, Mr. Chairman, Mr. Loop, and Mr. Short. Thanks for being here today. You mentioned quite a few states, Mr. Loop, that have passed these. What do you think is the model if we were to pick one to sort of be the base, a base that we start to maybe look at as we start to look at this? Is there one that sort of has been above the pack?
Yes, sir. In terms
Mr.
of
Luke, go ahead.
Thank you, Mr. Chairman and Representative Gray. Yes, I do. I think North Carolina is the one, but given the local, meaning state and regional tax structure that surrounds you, I think the 30-cent tax cap that North Carolina just enacted is the one that's more ideal for Wyoming to consider. And it was very simple. I think I may have provided that to you in earlier correspondence, but I'd be glad to send it to committee. It was basically 2 sentences that said, large cigars are subject to a 30-cent tax cap.
Okay, very good. Thank you.
And I'll provide
Any
that
other
North Carolina language to the committee. I'm sorry.
Okay, we appreciate that. Okay, Representative Gray, follow up? Did you?
Thank you, Mr. Chairman. I did have one other question. And can you talk a little bit more about how these taxes are aggregating? I don't smoke, so and we're generalists a lot of times. We're coming, so I just want to understand a little more how these taxes are aggregating, because I thought we talked about that earlier, and that was important.
Okay, go ahead, Mr. Luke.
Donovan, you want to take that, and then I'll reinforce your message about tax collection.
Okay.
The question, I'm sorry, again, is regarding how the taxes are aggregated on us quarterly?
Representative Gray.
Yes, thank you, Mr. Short.
So everything that we purchase of a tobacco nature, which in our case is exclusively large cigars and pipe tobacco, We effectively collect those invoices for the quarter. There are various, just general transactional purchases that happen. There are also large trade show type events, where the industry comes together in various spots, and sometimes we lay in supply for a little farther in the year at those. At the end of every quarter, we effectively add that figure up, and whatever that wholesale figure is, we write a check for an additional 20% of that and send it off to DOR. And again, it's very unlike sales tax, which is as products are sold. We're able to, it's 5% obviously in Natrona County's case, and we collect that up and submit the filing at the end of the month. So things have turned into revenue. We have collected that tax back from the customer while we submit. But in the case of OTP, it's very speculative, and it's quite a large burden at the end of every quarter when we're trying to kind of balance supply and purchases.
Well, if I can follow up to that, Representative Gray, I just want to note that the Virginia legislature confronted this exact same issue during their most recent session, and they fixed it through some legislative language that we can provide to the committee and staff, where instead of Mr. Short's shop having to pay the tax upon delivery to the store, it's able to be collected at the time of sale. And that obviously improves the cash flow for small businesses like Casper Cigar Company. And I'll provide that legislative language to the staff and committee as well.
Okay, thank you. Very good. Okay, Senator Pappas has a question.
Yeah, I'd like just a little clarification on what a large cigar is. Are we talking about, is there a definition out there? Does it go by ring gauge, or is it, a difference between you could have a Churchill or a small short story or a cigarillo? What is a large cigar?
Okay, Mr. Luke.
The general rule of thumb on that question is weighing 6 pounds per thousand. That's the general federal accepted and trade association accepted definition of a large cigar, 6 pounds per thousand.
Okay, Senator Pappas.
So, yeah, I've never not thought of cigars in pounds per thousand. What is that? What is that? If you divide it by 1,000, how big of a cigar is that?
I should pull out some visual aids. I'm not sure how to answer that. I'll get you some background information that'll address a more standardized approach to defining a large cigar. Would that be helpful?
I would, and I think Mr. Short, if you want to weigh in on that.
Also, is there a reason for even defining a large cigar? Why don't we just define all cigars?
Well, for federal tax, I'm sorry, I didn't mean to interrupt. For federal tax purposes, the TBB would define the importation of large cigars for federal tax purposes.
I wouldn't have much more to add. The most typical size that we sell in a cigar lounge is what's known as a Robusto, about a 50 ring gauge. But there are smaller, there are larger that meet the definition of the larger cigars. We're talking about mostly handmade products rather than machine-made products that are a little more popular in the C-store type environment, but it's a little different in your regular cigar lounges.
Okay, that answer here. Okay, Representative Sweeney has a question.
Thank you, Mr. Chairman. I don't know if it's for these gentlemen or Department of Revenue, but I just at some point would like some clarification that we're not attempting to dismantle what we do currently with cigarette taxation, and that it's not going to be a burden on the department in some way to try to. I remember the vaping category quite well, and that was a little tricky. So
we get to that point, I'm sure we'll have those. Appreciate that. Okay, any other questions? Mr. Short, anything else that you'd like to add? So Mr. Short, our timeline, what we're going to do we appreciate this information. And so at the end of our meeting today, we'll have directives to our staff for our next meeting. And I'm sure this will be a motion. The committee will move this idea forward. We'll get draft legislation. So that's how the process will work. And then I think our next meeting is in September in Casper. And that'll be well publicized. You'll see the bill drafts and all that kind of thing. Then we'll just go to work on it and start working on kind of that issue a little bit. So that's kind of the timeline. So we won't draft anything or debate any of it today, just so you're kind of, okay. Anything else to add to us? Appreciate you joining us.
Just very appreciative for the opportunity to tell the story, and I appreciate the committee's willingness to hear us out.
Okay, very good. I think one more question, Representative Gray, for Mr. Loop.
Yeah, I do have, thank you, Mr. Chairman. I do have one more question. I know we're going to get into the nitty gritty over the next 4 or 5 months, but Mr. Loop, so I guess you're saying that Virginia, that is a little bit of a different issue, the issue that they solved with that piece of legislation in terms of the point of collection. So it would be a potential merge of the North Carolina and Virginia approaches, correct?
Yes, sir. That would be my recommendation, is that you add the tax collection resolution to the tax cap legislation you may consider. So yes, sir, I would put them together.
2 issues really to fix. Yeah. To work on. Okay, very good.
Mr. Chairman.
Mr. Co-Chair Case.
Thank you. And Mr. Lube, I do have a question for you. Being a cigar industry lobbyist in the Washington, DC sounds like a dream job to me. How the heck did you get that? Wow. All those backfilled rooms and all that, I just can't imagine.
Well, I can tell you this, I prefer state capitals.
We do too, but
Yeah, very good.
thank you, sir.
Appreciate
Thank
you
you.
joining us. Okay, anyone
Thank you.
else? Okay, so we are again, we appreciate you joining us, and we're gonna close public comment on that. And members, we can, we can do directives now, or we could do them all. I've kind of got this list going from yesterday and today. So really, what's committee's play? We can take a directive now to the staff if we want to. Representative Gray, you want to make that motion?
Thank you, Mr. Chairman. Yeah, I think it's okay to do it now.
Yeah,
If we
sure,
could,
it's appropriate. You bet.
yeah, if we could make a bill draft motion for maybe use the North Carolina and Virginia approaches as the base. And I don't know, I'd like to get your input. Should we do a working group or just have communications amongst members, or is that?
I think it's pretty straightforward
Yeah.
issue. I mean, the cap and
Okay.
then the collection point. I think it's pretty, and I'm getting a head nod from our staff, so I think we're good. Probably don't need a working group for that. So we got a motion really on these 2 issues.
Yeah.
Is there a second? Second by Senator Baldwin. Okay, members, for the bill draft, all those in favor say aye. Opposed? Okay, so that draft will be in front of us at our next committee, and we'll see
Mr. Chairman.
versions of that as it keeps working through. Senator Pappas.
Mr. Chairman, was there any thought on any one in the committee about changing, we're talking cigars, about changing the tax on cigarettes? It's something we ought to talk about anyhow.
Well, I think, it's a good question. Representative Hallinan actually asked for that proposal. If you read his email today, he has a doctor appointment, couldn't attend, and wants a little increase to keep up with inflation. So, it's like 2 cents or 3 cents or whatever it was. I don't have the email in front of me,
Mr. Chairman,
Senator.
we visited this in the past about, I'm not so interested in keeping up with inflation. I'm more interested in, as Mr. Garrett had testified in actually bringing tobacco taxes higher to curb usage of tobacco. I supported it the last time. Of course, we didn't pass it. But I think we ought to think about raising them to a point that where it becomes difficult for our youth to
Well, and I think-
purchase them.
Just a comment, I think you're absolutely right as far as this is the time where we want to get all these ideas to go forward. I mean, so if we have a bill draft go forward, that's great. You want to bring ideas forward. We want to be the most educated group on all these issues. And then we'll decide at our next meeting whether it takes that next step and then get in front of the full body, which I think is important for us to do. And if you vote against it on the floor, great. But I think getting these ideas out is an important part of this. So that's my 2 cents on it. But go ahead, Representative Yan has a question.
Mr. Chairman, maybe a suggestion would be just have a directive to staff to have a bill draft with a placeholder number, and we can debate the number at our next meeting.
Sure. I think, folks, I really don't want to shut down any of these bill draft ideas at this point. This isn't, I mean, we want to get the ideas out there and get them moving. So go ahead, Senator Case.
Well, Mr. Chairman, there's just something we do have to point out. Fremont County is pretty unique, and we have tobacco products that are sold by businesses on the Wind River Indian Reservation that don't have the same level of taxation. And it creates an arbitrage problem for the local retailers. So they're like, you know, figure out a way to make it the same taxes on the reservation and off the reservation. And so we passed this committee, I think it was this committee, but it might have been the tribal committee a couple of years ago, passed authorization for the governor and the 2 sovereign nations, the Northern Arapaho and Eastern Shoshone, to enter into a compact for the establishment of tobacco taxes on an equivalent basis. Right now, what happens, and this is the wrinkle, you know, is that we base the collection of taxes on the reservation from tobacco sold on the reservation based on an old agreement that was an estimate of the percentage of people that purchased that were non-native that purchased tobacco products on the reservation. So essentially the tribal governments forward that amount of money, which is from a compact. I think it's almost 20 years old. I'm not sure if the Department of Revenue can help us with this. And so that amount of money goes to the state every year. But that was pre-casinos, pre-smoke shop, pre-everything that's happened on the reservation. So, and you know, and they don't assess it based on the color of your skin. They just forward this amount of money that they've agreed to pay the state. If we were to implement a compact that would allow for tobacco equivalents, it would work like this, hopefully, is that we would no longer worry about the color of the skin of anybody that's buying products or try to estimate which amount is native people and which amount is not. But what we would allow is that each sovereign entity to bill and keep the tobacco revenues for their own use. So for example, in the case of tobacco products sold on the reservation, that would mean that in the future, the tax would be the same on the reservation as is on the state or off the reservation, but that the tribal governments would be able to use those taxes as they saw fit. They wouldn't go through the Department of Revenue, or maybe they would and be remitted, but we'd have to work all that out. But they'd have control over that. And then on the other hand, they would assess the tax to everybody, native, non-native, everybody. And they could use the money for their own control programs, education programs, whatever. Similarly, the state would, on retail establishments off the reservation, they'd impose the same tax. And it wouldn't matter if a native person is buying or a non-native person, and that money would go to the state. So is everybody following me so far? When you have that kind of situation, you can raise the taxes successfully. It's problematic to raise the taxes too much because of this arbitrage problem where you can check on your way home, go by the smoke shop, see what the price of cigarettes are. And you can buy them for that price. So it's the local retailers, and this is where the petroleum marketers usually jump in with both feet. They might have missed this one, but they're the truck stops and all that. They argue that this is a really important point. I'm just bringing it up. It's educational. If we increase our taxes and keep going, it'll increase pressure to try to do something about the parity issue. But it does have unique problems here. And welcome to more of our unique Fremont County situation, but I appreciate you listening to it.
Very good. Okay, any other comments on this issue? Senator Pappas?
I think we need to pursue it. I like your ideas. I think they could be very workable. And because I do agree, we need to deal with the parity issue. But I, for one, believe we should increase it. I'm to the point where we ought to double it. But again, we could, discuss that number at a later date. But I would move that we include this in the bill draft as well. I don't know if you need a motion to include it in the bill draft, but an increase in cigarette tax.
Any other discussion on that?
Mr. Chairman.
And we can break this into multiple bills or however it works best at a later date, but Representative Sweeney
Well,
on the motion.
yeah. Yes, Mr. Chairman. So as it goes to the motion, the treaty is in the compact. I've heard those discussions and tried to encourage working through. And I don't know, I realize it's just a draft, but I would appreciate petroleum marketers trying to weigh in. We've made no progress, to my knowledge, on the compact. I know Governor Meade tried to work on it. I believe Governor Gordon has tried to work on it, but it's problematic to take action with a bill draft. And I do believe there is a representative for petroleum marketers, but if it be appropriate for them to weigh in, but I'll probably be a no vote. So,
Anybody else want to,
Mr. Chairman,
Mr. Co-Chair?
I definitely support moving a draft forward. Maybe in conjunction with this, another way to see what's happening with the compact is invite the governor's office to make a presentation to our next meeting on the status of the compact. I don't know how hard they're working on it. I know they've tried and brought it up. It takes all sides to make it work, but if we could kind of maybe even send a letter to the tribes and request, maybe try to circle around and get everybody back thinking about the compact, because it would be timely in light of this bill. Do it together, might be able to move the ball.
Mr. Chairman.
Thank you, Mr. Chairman. I agree this parity issue is something that maybe is the reason we've been dealing with for years and years, and it's the reason we're probably 44th in the country. And so I strongly encourage that we pursue it this time and try to get to the bottom of it. Thank you, Mr. Chairman.
Okay, Senator Pappas.
Yeah, Mr. Chairman, on second thought, if the bringer of my second would change it, I think this ought to be a second bill actually for cigarettes. And the parity issue, Senator Case, is it an issue for the cap on cigars? Probably not. Or is it would be just a cigarette tax issue?
My guess is it's not as relevant, Mr. Chairman. Thank you. Sorry to jump in. So it's probably not as relevant for cigars. I'm not actually thinking we can fix the parity issue in the tax bill. I'm just saying it's an issue that needs to be addressed, and in the past, it has killed the tax bills. And so,
Mr. Chairman.
Yeah.
So I'd like to amend my motion and ask for a separate draft bill than the one that Representative Gray that we passed earlier.
Okay.
Second's fine.
Okay, so we have that, and I think staff has that. Okay, and we're going to keep talking about it. It's not like we're making final decisions, but we're agreeing to continue to talk about it, I guess. If all in favor, any more discussion on that motion? Okay, all those in favor say aye.
Aye.
Opposed?
No.
Okay, so that motion's been adopted. We'll work on that. And I think if we can craft a letter from the committee to the governor's office and the tribes and just kind of get an update for us. So, okay, any other discussion on this issue? Okay, very good. The next item for our agenda, and everybody good? We're compared to yesterday, it's only been 45 minutes. Everybody good? You don't need. a break?
Finally get a good chairman on this and it
Yeah,
goes like
no.
crazy.
No, this is, okay, here's what I think this might go a little longer. So how about we just take literally a 5-minute? You look, actually we'll go about 8 minutes. So you look at that clock on the wall. So at 25 after, we'll take up the next topic on our LLCs and private trusts. Okay, so we'll just stand at ease for a few minutes. I just think it's this next one, it's on. Okay, members, and we're back at it now. And our next topic is limited liability companies, private trusts. We really just have appreciate the Mr. Co-Chair's work and all the folks who agreed to come really start telling this story to educate the committee. And so really our first piece on this primer is Mr. Chris Reimer. So go ahead, I'll just introduce yourself and who you represent, and appreciate you being here.
Thank you, Mr. Chairman, members of the committee. I am a partner at a law firm called Long Reimer Weiniger, and that's essentially my day job. But for many years, I have been involved in drafting and helping revise Wyoming's laws on trusts, various entities, including trust companies. I'm involved nationally with a couple of groups that also do essentially the same thing by comparing jurisdictions. I'm the state chair of what is called ACTEC, the American College of Trust and Estates Council. I am the national chair of another group called the Society of Trust and Estates Practitioners. And I'm not sure if this is why I was asked here today, but I have actually taught at the University of Wyoming the course on estate planning. And I understand my job is to give a very short mini class to the committee today on basically the Pandora Papers and what it means for Wyoming, so that you have a basis to help with your discussion with the various other stakeholders who are here to speak after I am finished. So feel free to interrupt me at any time, but my plan is to talk about three very distinct topics, all of which, if we discuss those, we'll kind of hit everything that's been in the newspaper lately. And those three topics are the so-called Cowboy Cocktail. Number two is the Wyoming Private Trust Company. And number three is the secretive shell company that you will see in the recent news stories about Wyoming and how that impacts registered agents and such. So the first topic, unless I have any questions before I jump in there.
Representative Gray.
Thank you, Mr. Chairman. I read the two memos that were part of our meeting materials. Was there a separate presentation, or is this going to be more verbal? Just want to have something following along if there is one. Thank you.
I have not prepared a presentation like in a PowerPoint sense of what I'm going to talk about today, but those three topics are in that memo, and I'm just going to distill it down basically verbally today, if that's okay.
Okay, very good.
So the first topic is that of the Cowboy Cocktail, and everybody is wondering what that is. Well, before I can tell you what that is, we need to take one step back and just describe for you what is a trust. So trusts are a English law thing. Any jurisdiction in the world that used to be part of England has trusts. Trusts require three people: the person who puts property into the trust, which is called a grantor or settlor, a trustee, which has legal title to property, and a beneficiary who doesn't have the same sort of rights that a trustee have, but is supposed to be legally entitled to benefit from the property. To have a Wyoming trust, you need to have a trustee in Wyoming. You don't need those other parties to be in Wyoming. Trusts are private. You will see the term private trust. Well, that describes all trusts. Trusts are private in that they do not file a document with any governmental authority to exist. So like a LLC or a corporation, to exist must pick a state and file a document to get a certificate of existence. A trust is governed entirely by private documents drawn up by lawyers. And that's true in all 50 states. Trusts, there are more trusts than the only limit on trusts is that which trust lawyers can cook up as to what trust could be used for. You will often see them referred to with acronyms. Some common ones are the QPRT or Qualified Personal Residence Trust, or the ILIT, the Irrevocable Life Insurance Trust. These are things that exist on paper, created by lawyers that have no filings in any state whatsoever. So with that as a background, I will move to the Cowboy Cocktail, which involves a trust. First, I would like to tell you that in 17 years of practice, I had never actually heard the term Cowboy Cocktail before it came out in some newspaper articles last December. And people actually ask me, what is that? I don't have that, Chris. I need that. And I would say, I don't know. I think somebody just made it up. I literally don't know. And so I looked in the internet for a while and actually getting serious by searching in a database which lawyers use to do legal research that includes published law review articles. We found one hit to the term Cowboy Cocktail in a law review article about divorce. And I gave you the relevant pages of that article. You don't need to read it, but just to know that that's where we were able to find that term. And that author, thank goodness, captured the flyer created by lawyers that use that term in her own research, so that we didn't find it online somewhere. We actually found it as a citation to an article that had been preserved. And we included that flyer in your memo that you have received. It's a one-page flyer talking about asset protection planning by two lawyers from, we think, 2011, because at the bottom left-hand corner, you can see that it was copyrighted as of that date. Just as an aside, neither of the lawyers mentioned in this flyer are members of the Wyoming Bar. So a simple search at the Wyoming Bar Directory online would confirm that for you. That said, if you just look at their list of asset protection items, they call under number 5 the Cowboy Cocktail, and they describe it as a combination of an LLC and a DAPT. Well, an LLC is a limited liability company, which all 50 states have. Interestingly enough, they were first adopted in Wyoming in the late 70s, and now all states have them. And they also say that to have the Cowboy Cocktail, you also need a DAPT. Well, that is a trust described by an acronym, like I described, and it stands for Domestic Asset Protection Trust. A domestic asset protection trust is defined by being a little unique in that rather than the 3 people that I described to you that you need, the person who creates it, the trustee, and the beneficiary all being different people, a domestic asset protection trust, by definition, includes the same person who creates it and is a beneficiary. So it is an asset protection tool for somebody who wants to hold assets in trust and have some asset protection coverage with respect to that asset. They are not unique to Wyoming. 19 states have domestic asset protection trusts. I just checked yesterday before I drove down here. And although I would never call it the Cowboy Cocktail, this is a standard procedure for any client who wants to hold an asset that is particularly dangerous from a litigation perspective. And the easiest example I can give you that I've done numerous times, and I have one in my mind that I need to call and tell them they have the Cowboy Cocktail because they don't know, is I have a client with a house on Garfield Street in Laramie, very near to what, at least when I was in college, was called the Library Bar. I don't think it's called the library anymore, but it's a bar right on Grand Avenue across from the dorms, with college kids constantly rented out right next to a bar, which activity could occur even in front of the house, having nothing to do with the occupants, that could lead to liability. And so in that case, we have that house not owned individually by the client person, but first by an LLC. So if you were to go look up the records of who owns that house, it's an LLC. And then the member of the LLC, rather than being a person, is a so-called domestic asset protection trust, which is allowed under Wyoming law and 18 other states. So it's a standard thing. And the point of it, asset protection has historically comes from two places, one from company law, one from trust law. This is simply blending those two in a single structure to take advantage of both. You will see in the articles a suggestion that this using an LLC plus an asset protection trust, the Cowboy Cocktail, is somehow a tax shelter. And that is ridiculous. Nothing under Wyoming law, anything on this sheet of paper, anything in any of our company or trust laws would allow any person from anywhere to create a Wyoming structure and reduce federal taxes. The only tax play involved with any trusts in Wyoming or companies is that there are states that impose income tax on their residents, and those residents include people and trusts and companies. So the game is, if you have a particular trust in a state like California that imposes a rather hefty income tax, and you have a trustee with a trust there, they would be interested in moving the domicile of that trust from California to a state like Wyoming that does not impose a tax to reduce or completely eliminate California taxes. And that is not a simple thing to do. In fact, most times when clients call and say, I want to move my trust, we tell them it would be a waste of your time because your income in that trust in California comes from an apartment building in California, or from a business that employs people and offers services in California, which California is going to tax from now until the end of time. And there's no way, nowhere in the world that you can go move your trust to avoid that taxation. What you can do in the right circumstances, if you have a trust that holds nothing more than intangible assets like stocks, bonds, and cash, has no tie to California, you can move the trusteeship from California to Wyoming and turn off the California income tax. That is the sum total of the tax minimization game that is completely glossed over by the news media to say that Wyoming is used as a tax shelter, which from a federal tax standpoint, that's false. And there is a little bit that you can do in the right circumstances as among states. This is the Revenue Committee, which is not lost on me. And so I will just say, if the state of Wyoming were to impose a tax on individuals who are resident or resident trusts, the resident trusts would be the first to leave because they don't have to pick up their lives and move like people do. They literally just have to change trustees. So they would all go overnight to our competitor jurisdictions like Nevada, Delaware, Alaska, and South Dakota. There would be no ongoing tax base to impose an income tax on those trusts because they would just leave. Speaking of South Dakota, I would like to draw your attention to the final page of the memo that we prepared for you, which is a schematic prepared by the Guardian newspaper in the UK about the Pandora Papers. And these news people actually went through the Pandora Papers and made a graph and counted up the trusts and created a visual of what state those trusts are currently in on this graph. And so if you look, you'll see at the top bar, there are 81 in South Dakota and 2 in Wyoming, and a host of other states that have 1 or 2. And this is not surprising to me. The reason for this is that there's no market and there's no ongoing push for people who are in the Pandora Papers for whatever reason that have foreign trusts and foreign money that they want to bring into the US. There's no market for them to call up a local bank of a Wyoming bank, a local branch of a Wyoming bank, and say, we'd like to move our trust to you, because there is no there are no systems in place in local banks to even bring those dollars in if they wanted to, because they have to comply with the anti-money laundering laws, the Patriot Act, know your client regulations. So what happens is those people call large banks in New York, Miami, Los Angeles, and those large banks have a historical connection with affiliates in South Dakota. So the onboarding work of all this know your client stuff and the vetting of clients all happens in big national offices of these banks. And then they end up settling out into South Dakota, by far the #1 destination, because of the historical connection between large banks and financial institutions and South Dakota based on the credit card industry. All of the major credit card facilities of all the major banks are located in South Dakota. It's beyond the scope of me to explain to you why that is today, but if you just were to Google South Dakota credit card industry, there is more online than you would ever want to read about why that built up the way that it did. That's all I have to say about the Cowboy Cocktail. And I would move on to the Wyoming Private Trust Company, unless there are questions specific to the Cowboy Cocktail.
Representative Yin has a question.
Thank you, Mr. Chairman. Mr. Reimer, so a person who's a beneficiary of a trust, would they get taxed by their home state if there's a capital gains tax from money that goes from the trust to the person?
Thank you for your question, Representative Yin. In that example that I gave earlier, where we moved a trust from California to Wyoming, it wouldn't pay California taxes on its earnings. But if it were to distribute dollars out of that trust to a beneficiary who happened to be in California, federal law would require the Wyoming trustee to issue a 1099 or K-1 to the IRS, which would share that information with California and the California taxpayer beneficiary. So at the end of the day, if you take the money out of a trust that is sitting in a jurisdiction like Wyoming and you are a beneficiary in a state like California, absolutely, you're going to pay tax.
Very good. And Representative Baker has a question.
Thank you, Mr. Chairman. I have 2 questions. One is just kind of just to understand the basis of how the information was gathered. So if these are private documents, then how do they really go about gathering the figures that you provided on the graph that shows? How do we know if these are private documents? Is it like a survey done to a trust attorneys, or how do we get that information?
Thank you, Mr. Chairman, Representative Baker. So when the Pandora Papers are described, those are private documents that were leaked to the media by some party. And I don't know exactly who the leaker was involved with the Pandora Papers per se. It sticks in my mind from the Panama Papers, which was an earlier leak. There was a law firm involved in that leak called Mossack Fonseca. So that was a particular law firm in Panama that did this work. Their information was illegally obtained. Private information just became public information, and anyone can go right now and look through what are private documents because they've been leaked to the media. There's a place that you can go online and search through the Pandora Papers should you so choose to do so. I haven't done that. The people who work at The Guardian, which is a UK newspaper, did that. And there's a link to their article here at the bottom of this graph. And this is just a graph that those news media people put together, sifting through those, what were private documents, but then were leaked to the media.
Thank you, Mr. Chairman. Along a different line, so we have the Cowboy Cocktail, which is a Wyoming LLC owned by a Wyoming Asset Protection Trust. Thinking about this in the future, have you had any clients that have, I guess maybe proposed Dow owned Wyoming Asset Protection Trusts? Like the decentralized autonomous organizations that Wyoming has created?
Thank you, Mr. Chairman. I don't recognize what you're asking me. I'm sorry. So the answer is no. I don't have, I've had 0 clients ask me what it is you just asked me. Thank you, Mr. Chairman. So we've covered the first and longest topic. The other 2 will go much quicker. The second topic is that of the private trust company. So to understand what a private trust company is, you must know that when you are selecting a trustee for a trust, there is a spectrum of choices. On the one end of that spectrum is a living, breathing person. You can just have a person be the trustee. On the other end of that spectrum is to hire a bank whose trust department would be the trustee of your trust. A private trust company is right in the middle of those 2, in which it is a private company, either an LLC or a corporation, created by a particular family to use as the trustee of their own family trusts. It doesn't have any interaction with the public whatsoever. It's used by a family who already has trusts. And typically, these are large family trusts with robust family offices who already have personnel in place that deal with these assets on a day-to-day basis anyway. And on the one hand, if they happen to have a relative or old college roommate who lives in Wyoming, they could name that person and have a Wyoming trust, but that's usually not what we would recommend to somebody. Just name a random Wyoming person as your trustee. And they could hire a bank, but we often find that when you have these large family trusts, which often have privately held family business assets, these are operational families that own businesses. They have people in place who know those assets, know those trusts, and they don't want to just hire a bank or trust company to supplant them and make company decisions. And frankly, most banks and trust companies wouldn't want to do that job anyway. Banks and trust companies would either prefer to serve as trustee of trusts that have cash, stocks, bonds, things that they can go out and make a reasonable allocation in the market for, or if they are stuck with holding a family operating company, they have all kinds of things they can do and ways to indemnify the trustee from not being in charge of the company. Like, you want the company to be in the trust, great, but we're not going to run it. You got to bring in your own people to run it. So the private trust company solves the problem of needing sophisticated people in place in a good jurisdiction like Wyoming that allows them to have their own trustee for the family business. Private trust companies are not unique to Wyoming. There are 17 states that allow them, which I confirmed before coming down yesterday. Generally, private trust companies in Wyoming are not automatically regulated by the Division of Banking. And that's because they don't interface with anybody other than themselves. This has been the law in Wyoming since 1993. We included a memo, an opinion letter from the Attorney General from 1993, which basically gives you the history of why that's the case. We don't rely on that memo anymore. Private trust companies are written into the statutes now as initially being not regulated by the Division of Banking. But if a particular family wanted to be regulated in Wyoming, it's possible to go to the Division of Banking and apply for a charter and be regulated. And a handful of very large families, large trusted families with large trusts have done that with a Division of Banking. And they usually choose to do that because if you're regulated by the state, you're automatically not regulated by the federal government for several purposes, including securities regulation. So talking about that anymore is probably outside the realm of what we need to do today, but just know that a private trust company is something that's available in 17 states. Wyoming's been doing it since 1993. They don't bother anybody. They're generally not regulated, and they are certainly not the linchpin of any sort of tax shelter, like how the tax shelter of how a Cowboy Cocktail is described as a tax shelter. Going back to that flyer from the two lawyers, they described the ultimate Cowboy Cocktail as what I just described to you is, say, the house in Laramie with the trust owned by the LLC. Well, the trustee of that trust would be a Wyoming private trust company to be the ultimate Cowboy Cocktail. It's not a tax shelter in any sense of the word. It's something that many families use. And as I said, it's available in 17 states.
No question. Here, Representative Henderson.
Thank you, Mr. Chairman, and thank you very much for this information. Before we go too far, I mean, one of the things that helps Wyoming, I think, is the leadership, but also the unique development as we've started the LLCs and then with the trust. So could you briefly just say what you see the role of registered agents in this, and also the trustee, and more particularly the value of what does the trust, having our trust statutes in Wyoming, what does that bring in terms of value to the participants, the beneficiaries, of course, but also the people who own those assets that are in the trust? Briefly.
Thank you, Mr. Chairman. Representative Henderson. When I started practicing, I think there were two so-called non-depository trust companies in Wyoming 17 years ago. I just looked on the Wyoming Division of Banking website yesterday, and right now there are 21. And I hear there are 2 more ready to come out. So there are really 23 trust companies. Those are companies who are regulated by the state. They offer services to the public at large. And that shows to me basically the growth in this industry from the time that I started. I didn't prepare for you, and I don't have data on like how many people that means are working in Wyoming in the trust industry, but I know that the Wyoming Trust Association personnel who are speaking third today would be able to address that for you way better than I would be able to. So I'll move on to your other question, which was to discuss how this impacts registered agents, if that's okay. That actually is my third topic. So I'm ready to move on from private trust companies and talk about registered agents if we're ready to do
I
that.
think Senator Pappas has a question.
Yeah, thank you, Mr. Chairman. Just for my knowledge and to enlighten my ignorance, I know a lot of trusts are labeled living trusts. Is that different than any other trust? Can you explain what a living trust is?
Thank you, Mr. Chairman, Representative Pappas. So a living trust is a term that describes a trust that is completely changeable and revocable by the person who creates it at any time. And in Wyoming, we use living trusts literally for anybody who walks in our door and owns real property. So we tell people not to own real property in their own name, but to own it in a living trust, which is essentially a will. If you were to look at a living trust and look at a will, they look the same. You can go change them whenever you want. They have no tax existence. Anything you put in a living trust is yours. It's not like you're giving it away. No tax identification number. But the reason we use living trusts for basically everybody in the state of Wyoming is that if you as a person die owning real property, your estate is administered by the probate court, which is a formal proceeding which takes about a year. Lawyers take a 2% fee. And by simply adopting a living trust, which is as easy as signing a will and deeding your real property into the living trust, you avoid that court process, and the administration of your estate is handled entirely privately with no court involvement whatsoever. Thank you, Mr. Chairman. My final topic today in the short course on the Pandora Papers in Wyoming is the so-called secret shell company, which you will see referred to in the Pandora paper type articles. The most important thing to take away from this is that a so-called secret shell company, which I'll describe to you what that is a thing of the past. It is over. So last year, the federal government passed the Federal Corporate Transparency Act, which means every single corporation or LLC filed in Wyoming or any state in the nation, as soon as the regulations are finalized and they tell us where and when we have to go do this, we have to tell the federal government the full legal name, birth date, current street address, and identifying number from an acceptable form of identification, like a passport, state ID, or driver license of each beneficial owner of any corporation or LLC ever filed. Beneficial owners include trusts if the trust owns 25% or more of the entity. So my guy who owns the rental house in Laramie next to the bar, under these new rules, is going to have to make a filing and tell the federal government that his LLC exists and that the LLC's member is a trust, because the trust owns more than 25%. In this case, it owns 100%. And the beneficial ownership information of the people under that trust are going to be given to the federal government. So this idea, it is true, before the passage of this law, you could go to certain states and form a company and not tell any governmental agency, state or federal, who exactly the owners of that company were. As a practical matter, that doesn't impact bad deeds like money laundering and terrorist financing and the things we're worried about with shell companies, because if you take your shell company to the banks make you and have to, under federal law, disclose who the beneficial owners are and what's the source of funds. And they have to run names against what's called the OFAC list to see if your name is subject to sanctions or what have you. So it's never really been a problem that we have so-called secretive shell companies. But for whatever reason, the federal government has said, enough. If you form a company in the United States of America, we don't care where, the federal government is going to have a database of every underlying owner. Period.
Question, Senator Pappas.
Yes. So if 25% is the threshold for making notification or having to apply, having to tell them who you are. If I had an LLC with 5 members and each were 20%, would then would that be basically not have to be, I wouldn't have to tell the federal government who those 5 members were?
Go ahead.
Thank you, Mr. Chairman. Representative Pappas, the LLC would still make a filing and it would still say there are 5 members and here's who they are. I haven't actually done this yet because the system isn't online yet for us to go and do this. But my understanding is those trusts would be disclosed. Those trusts themselves wouldn't have to go make a filing. A trust, if it owns 25% or more of an entity, is going to have to do this filing. That's my understanding of how that works.
Mr. Chairman, well, that would be, in your case, the guy in Laramie, he owns 100%. But what if there were 5 trusts in this LLC? Would they not, since they're only 20% and not 25%, would they not have to disclose?
Thank you, Mr. Chairman. Senator Pappas, my understanding is that each of those trusts wouldn't have to make their own filing, but they would in fact be disclosed under the filing of the LLC, which has to say who its members and owners are. I've never done this. Nobody's done this because the rules are still being the system, this massive federal system of compiling information on all these entities in the United States of America isn't up yet. The law has been passed, but the system's not in place. So I can't answer you any more than I understand that the filing for the LLC will be made. The government will know who those 5 trusts are, but they won't necessarily have a separate filing per trust of those 5 trusts. Now, if you wanted to go open a bank account for that same LLC with 5 trusts, any banker is going to say, show me the trust, prove to me who the ultimate beneficial owners are, and show me the source of funds of where the funds are coming in from the trust. You're still going to be subject to the banking regulations, which have always been the gatekeeper in our system of stopping bad money from coming into the system.
Okay, thank you, please.
Thank you, Mr. Chairman. My final point is that I would suggest that Wyoming certainly doesn't need to pass its own law regarding gathering information about ownership of entities, since this federal law is rolling out. I would point out that the rules that we know so far say that the Secretary of State's office in Wyoming and all of the 50 states are going to have to tell any person who files a company in the state of Wyoming that they must go make this filing with the federal system and actually give them the link to go and make the filing. If you fail to make the federal filing, the penalty is $500 a day for civil, and it's jail time for criminal. And the background information on the law specifically says that this database is going to be available to law enforcement agencies, including state law enforcement agencies. So if for whatever reason the state law enforcement needed to know, hey, who's behind ABC LLC, there will be this database that they can go to. And I would suggest that the state doesn't need to create its own, certainly not before this federal law is allowed to roll out and we can see what it does. That concludes what I had to say today, unless you have any other questions
Okay,
about those items.
We'll start down here with Senator Schuler.
Thanks, Mr. Chairman. Just a quick question. In terms of how we regulate these private trust companies and some of these other things, how is it that, I mean, are we similar, I guess I'm asking, in terms of Nevada, South Dakota, some of these other states that have maybe looser regulations? And is it a good thing, or do we need to be doing more regulation?
Thank you, Mr. Chairman. Senator Schuler, of the 17 states that have private trust companies, there are generally, there are some who have what we have, which is the choice to be regulated or not. And I would tell you that that's the best choice, just because it allows, when families are looking for their jurisdiction of where they want to settle, it gives them the greatest number of options. Never once have I been involved with a situation where a private trust company has done something wrong and I've had to defend them, say, in front of the Division of Banking as to what they did. I have been involved in situations where family members who are fighting turn each other into the Division of Banking, and I will get a call and that's the end of it, because that's they're not doing anything with respect to the public at large. But if, for example, a private trust company were allowed to just offer services to anybody under the sun, hey, I'll be your trustee, pay me money and I'll do these things, that would be bad. And that is not allowed in any jurisdiction that I'm aware of. Private trust companies, by definition, in the states that allow them to be unregulated, may only serve a single family. I'm oversimplifying there because there's a few cases where you can do 2 families, or some states, even allow 3 if you can prove this related nature. But it is a single family's choice to use that as a tool, and it usually works for them and it doesn't hurt anybody else. And I I think you have the Division of Banking here today, but you should ask them whether they think anything positive would come from forcing the Division of Banking to actively regulate all private trust companies. And I can't speak for them, but I would guess they would tell you no.
Mr. Co-Chair.
Mr. Chairman, thank you very much. Just a couple things about the 17 states that allow for the private trusts. And I understand, I definitely understand your point about it being unregulated, but do any of those 17 states have different levels of regulation of them? I assume they do. And just to tag on about not waste people's time, but I understand that in Wyoming, we allow for a private trust really because of a administrative exemption. I don't know if that's true, but that's, you read stuff on the internet. Wyoming and Nevada allow for unregulated private trust by administrative exemption, apparently. But the rest of the states have more statutory guidance on that. I don't know if that's true or not. That's what this one source is saying.
Go ahead, Mr. Ryan.
Thank you, Mr. Chairman. Senator Case, that is not the case.
Okay.
In Wyoming, under Title 13, Section 5, don't quote me on this one, 101 is the definition of a private trust company in our statutes, which defines what it is, defines the family for which it may serve, and statutorily requires upon its creation to make a filing with the Division of Banking, pay a $250 fee to let the Division of Banking know that they exist. And the Division of Banking will send them a letter back saying, thank you, we know you exist, and you're not seeking to obtain a charter. So the Division of Banking is made aware by statute when every private trust company is created by statute. This suggestion that it's some sort of administrative or regulatory exemption is false.
Okay. And then, Mr. Chairman, is that the end of it? And do all states treat it the same? If you have a private trust company, that's the extent of the regulation? You register with the state like that? Or do more states do more regulation of private trusts? I'm not suggesting it's a good idea or not. I'm just trying to understand the lay of the land. Go ahead.
Thank you, Mr. Chairman. Senator Case, there's a spectrum. So if my understanding is in Nevada, for example, there are only unregulated private trust companies. You may not go ask the Nevada, I could be wrong on this, but I'm trying to answer your question, that on the one end, there are states that have no chance for oversight. And I think Nevada is one of those. On the other end of the spectrum is Alaska. So in Alaska, if you want to be a private family trust company, you must choose a bank to be your home. And your regulation is essentially gathered up when that bank is subject to its regulation. It is not a one-off single thing that you can create and be unregulated in the state of Alaska. So it's a spectrum.
Go ahead. So my other question is kind of in a different area. It might seem like it's unrelated, but we have a rule in our Constitution against perpetuities. We used to hear it in debate all the time. And I understand there's a way to have a trust in Wyoming that has a very long life. I've seen advertisements and, it's all this junk where people are peddling stuff that say that a trust in Wyoming can be established for 1,000 years. Is there any truth to that? And how does that fit with our rule about perpetuities that kind of comes about and the Constitution? And you help me.
Go ahead.
And I know this is kind of from left field, but I appreciate it.
Thank you, Mr. Chairman. Senator Case, Wyoming has a statute adopting the common law rule against perpetuities, which is 21 years plus lives in being with respect to most matters. However, the statute says with respect to trusts, which have Wyoming trustees, the termination period or perpetuities period for a trust may be no longer than 1,000 years. So that's black letter statutory law in Wyoming that yes, a trust may last up to 1,000 years.
Mr. Chairman, forgive me, I should know this, but is there a constitutional issue about perpetuities that you're aware of?
When this, thank you, Mr. Chairman, Senator Case, when that statute was passed, there was lots of debate as to what the number should be. And I am aware of Attorney General memorandums that were prepared on the matter. There was, people like me showed up to actually testify when that rule was adopted. And so my understanding is that there is not, because it is defined as 1,000 years under the statute. Whether there's some law school type question of is 1,000 years perpetuity and the number should be, like, for example, in other states it's less, like in Nevada it's 360. So perhaps, but not to my knowledge, no, there's no fundamental constitutional problem with that.
Thank you, Mr. Chairman. Thank you, Mr. Ryan.
Okay, other questions, Representative Yen?
Thank you, Mr. Chairman, Mr. Reimer. Some of the Pandora paper articles seem to mention foreign nationals and foreign nationals using trust to prevent discovery from their home government being able to discover their own, the foreign nationals' assets. Are Wyoming trusts being used to prevent foreign governments from accessing their own citizens' money? And is it worthwhile for Wyoming to do something different for US citizens versus foreign nationals? Thank you, Mr. Chairman.
Thank you, Mr. Chairman. Representative Yin, as a practical matter, there is this concept that you just described, which is a foreign person, if they have money in a US bank account, the United States of America doesn't automatically share information with all countries in the world. We have a system called FATCA that we force other countries to tell us all information about Americans who have money in other places in the world, or they can't do business with the US. They're essentially shut out from being in the banking system. So it's a one-way rule in the US generally. As a practical matter, all of the large financial institutions that would even allow a foreign national's money to come in and open an account must certify whether that account is compliant with what is called the CRS, or the Common Reporting Standard. So the Common Reporting Standard involves lots of nations around the world. It's a little different than FATCA, which is what the United States has adopted. And so if you're a US person and you want to put money in a foreign bank, the United States government is going to find out about it. The rules regarding foreign governments forcing us to give them information is less strong. But as a practical matter, all of the national and multinational banks, if you just look at their intake form, they say on there whether they have been CRS compliant, and that information generally, I would tell a client, you better expect it's going to go back to your home country in one way or another. And I would never suggest, no attorney in the Wyoming or in the US tax system would suggest that you could hide money in the US from your home country.
Follow up. Thank you, Mr. Chairman. So just briefly, do you know maybe on balance how much business for Wyoming companies that help establish trusts come from foreign nationals versus US citizens?
Thank you, Mr. Chairman. Representative Yin, I can only speak to my practice, and I would say less than 25% involves any sort of foreign element that I'm involved in. But I would imagine that the people who are here from the Wyoming Trust Association might be able to give you more information from a statewide perspective than I just personally could.
Senator Pappas.
Thank you, Mr. Chairman. I know that the legislature has set certain fees for chartered trust companies. that are paid to the Division of Banking. And by the information that was provided to us, I guess the Wyoming Trust Association has supports increasing those fees. So I'd like to know, what are the fees that are paid right now, and what would the association recommend for an increase?
Thank you, Mr. Chairman. Senator Pappas, I would suggest that the two board members and president from the Wyoming Trust Association who are here answer that question, if that's okay.
Okay, I think we've about exhausted questions. Really appreciate the learning experience. Really good. Appreciate your preparation and all your work and all your help.
And Mr. Chairman,
Co-Chair?
I'd like to thank Mr. Reimer too, but hope that you would stick around for the rest of the discussion this morning. Perhaps we have some more back and forth if you could be available.
Yes, thank you, Mr. Chairman. Senator Case, I was planning on staying and maybe approaching the bench here during the public comment period in case any of you had any questions that came up during the interim that I might be able to address. And so I'll plan on doing that.
Perfect.
Thank you.
Thank you, Mr. Chairman.
Thank you. Thank you. Okay, next on our agenda, we have our folks from the Wyoming Trust Association. Do all three of you, are all three of you here? You want to all just come up together, or whatever is best for you guys, whatever works best. Appreciate you being here today, and you're on the agenda so that the public can see. So if you just want to introduce yourself and then the floor is yours. And then make sure your mic is, and you kind of get them a little closer sometimes, just so. Very good. Thank you.
Is this good? Perfect.
So we'll let you know.
You're going to have to point it at you as you share it.
Thank you, Chairman Case and members of the committee. On behalf of the Wyoming Trust Association, thanks so much for the opportunity to speak about Wyoming's trust industry. I'm Betty Andrikopoulos, president of the Wyoming Trust Association and one of the owners of Willow Street Trust Company. I'm joined by two of the directors from the Wyoming Trust Association, Amber Noose, partner at McGee Hernan Pies, a Cheyenne-based accounting firm, and Scott Weaver, our general counsel and chief fiduciary officer. By way of background, the Wyoming Trust Association was formed by trust companies, law firms, accountants, insurance providers, and others in order to provide a forum for industry collaboration and to ensure that Wyoming retains and enhances our reputation as a top jurisdiction of quality and integrity. Our position is that a strong trust industry benefits the state of Wyoming and that existing federal and state laws and regulations are effective at preventing unlawful financial activity using Wyoming trusts. As practitioners in the trust industry, we're pleased to speak as to how existing laws and regulations are implemented in practice, as well as how the trust industry benefits Wyoming's economy and its citizens. As mentioned by Mr. Reimer, a trust is a legal entity that is managed by one party, the trustee, for the benefit of another party, the beneficiary or multiple beneficiaries. Trusts have been in existence for centuries and serve many valid purposes, such as preserving a family farm or ranch. In our family, for instance, we have owned an operating cattle ranch in Daniel, Wyoming, oil and gas mineral rights, and medical diagnostic facilities throughout Wyoming, all owned in LLCs, which are owned by multiple trusts for the benefit of multiple family members. This trust and LLC structure has empowered our family to effectively and efficiently manage our multiple Wyoming businesses throughout the years. As a matter of framing, we would like to distinguish between privacy and secrecy. Privacy means limiting access to information to those who have a right or a need to know. Secrecy, on the other hand, is withholding or concealing information from those who do have a legitimate reason or right to know. For example, if I call Mr. Weaver's bank and ask for his account details or balances, the bank won't give me that information because I don't have a right or a need to know. That's privacy. On the other hand, if the Wyoming Division of Banking or the Internal Revenue Service or other regulatory authority contacts that bank with a question about Mr. Weaver's account, the bank will likely provide that information as part of a regulatory inquiry. There's no such thing as a quote unquote secret Wyoming trust. Banks and trust companies are subject to multiple independent layers of regulation by the state and federal government, as summarized by Mr. Reimer. And that's both prior to accepting clients and on an ongoing basis. We must know the identity of the clients and the ultimate beneficial owners of Wyoming trusts. And we are expressly prohibited by federal and state laws from doing business with any person or firm that are subject to any US sanctions. Specifically, the Wyoming Division of Banking oversees and examines bank trust departments and supervised trust companies and has access to all client records on an ongoing basis. Banks with national charters are also regulated by federal agencies. In addition, both state and federal depository banks may have supervision by the Federal Reserve and Federal Deposit Insurance Corporation. Wyoming banks and trust companies are also required to comply with federal anti-money laundering, Bank Secrecy Act, and Office of Foreign Asset Control laws, as is the case with all regulated financial institutions in the United States. Anytime a trust engages in a financial transaction, be that opening a bank or brokerage account, sending or receiving funds, purchasing or selling real estate, or making other investments, that trust is required to provide information about the trust, its beneficial owners, control persons, and tax treatment so that the institution involved may satisfy its own regulatory and compliance requirements. Finally, trusts, as with all other taxpayers, are required to file tax reports and pay amounts due to the Internal Revenue Service. Different trusts have different tax treatments, but all taxable activity is ultimately reported to the IRS, either by a trust as its own taxpayer or by interested parties. Multiple checks and balances exist within the tax reporting system that are designed to effectively ensure tax compliance across trust and business activities. As to economic benefits to the state of Wyoming, the financial services industry, which includes the trust industry, has been a successful diversifier for Wyoming's economy. Today, Wyoming is a top US trust jurisdiction, and that's because of the legislature's ongoing efforts to update and enhance our trust and business statutes. The Wyoming Trust Association's 18-member firms employ over 220 individuals located in 13 Wyoming towns. Beyond Wyoming Trust Association membership, there are 14 other trust companies or bank trust departments that also offer services. According to the University of Wyoming, each dollar earned in the state of Wyoming generates $1.63 of spending in Wyoming, meaning our trust clients, in addition, use local Wyoming attorneys, accountants, banks, and other services, in addition to employees spending money in the state. As has been previously touched upon, trusts and trust companies are taxed in exactly the same way as any other Wyoming individual or business entity at the federal level. Imposing an additional state-level tax on trusts would result in those trust company clients leaving for other states that do not impose such a tax: Delaware, South Dakota, Nevada, New Hampshire, Tennessee. So, as Mr. Reimer mentioned, such taxes would not generate meaningful revenue for the state because the tax base would evaporate, and it would negatively impact Wyoming's economy. Trust companies, law firms, accountants, depository banks, and other Wyoming businesses would lose business when trust clients leave Wyoming. In sum, the Wyoming Trust Association believes that the existing regulatory framework created by both federal and state law effectively precludes the type of financial crimes that have been implied, and that the trust industry provides good, stable, high-paying professional opportunities to Wyoming citizens. Chairman Case and committee members, we would now be pleased to answer any questions. Thank you.
Okay, thank you. Members, any questions? Representative Henderson has a question.
Thank you, Mr. Chairman. Just a quick question on the, you said there's 213 jobs essentially, right? 13 trust activities, 14 entities. How many registered agents are there in Wyoming?
Who would like to?
Mr.
Go
Chairman,
ahead,
I'll
just
address the
introduce
que-
yourself. Yeah, while you're first. Go ahead.
Scott Weaver, I'm a director of the Wyoming Trust Association. I'm also general counsel and chief fiduciary officer at Willow Street. Representative, thank you for the question. I'm not sure how many registered agents are actually commercial registered agents exist in the state. That might be a question to address to a representative from the Secretary of State's office.
Follow up? Go ahead. Thank you, Mr. Chairman. I would agree. I'm just trying to get a connection here between, the nexus of the LLC entities and the good things that are being offered and done in the trust administration sector. That's the aim.
Thank you, Mr. Chairman. Representative, I understand the question a bit more now. I view those two services as related, but for the trust industry, our company and other supervised trust companies are regulated by the Division of Banking. We have an ongoing relationship with our clients that is a fiduciary relationship, i.e. we have legal obligations to carry out the terms of the trust in accordance with the trust and then applicable Wyoming or other state law. And so oftentimes in the discharge of those obligations, either the structure that we have become trustee of, or we as trustee determined to organize LLCs that are owned by that trust. So you have a Wyoming trust that is determined to form a Wyoming LLC. And of course, every LLC needs a registered agent to accept service of process within the state of Wyoming. And so in that regard, I believe that Wyoming LLCs, as Mr. Reimer mentioned, are often used to segregate assets that are owned by a trust. For example, if a trust had an operating ranch and then it also had financial assets, you might choose to segregate out that operating ranch into its own business enterprise, as families across Wyoming do.
Peace, and then Senator Pappas.
Thank you very much, Mr. Chairman. Well, I do have a question about fees and, for example, like the regulatory activities of the Division of Banking, what fees do you pay? And we can hit them up too as well. And then I would assume that unregulated private trust, although I guess there was the mention of a $250 fee, I guess. And so if you just kind of discuss the fees, and I'll tell you where a little bit of it goes. For the Secretary of State, a lot of our corporate fees are based on the amount of the assets that are employed in Wyoming. So, I mean, there are people out here running and saying, well, we ought to get 1/10 of 1% of these billions and gazillions of dollars. So help me with what the fees pay. What do the fees mean in relation to the other states and kind of in that area, if you don't mind? I appreciate it.
Go ahead, whoever
Thank
wants
you.
to answer.
Thank you, Mr. Chairman and Senator Case. I'll defer to the Division of Banking as to the specific fee schedule and the way that that's been developed. The Wyoming Trust Association has previously been on record as supporting increases to those fees. I think the Division of Banking would be best positioned to describe what their regulatory costs are for supervising our industry, make recommendations, but we have previously and continue to support increasing in fees to make sure that our industry is appropriately supervised and Wyoming's jurisdictional reputation is appropriately stewarded. As to the registration fees for limited liability companies, as Mr. Reimer mentioned, a Wyoming private trust company must either be a Wyoming corporation or a Wyoming limited liability company. And so it already pays fees as part of its annual registration process. And to the extent that those trust companies have assets in Wyoming, those are part of that percentage fee in addition to the base filing fee.
Mr. Chairman, can I follow up?
Yeah.
Would all unregulated private trusts, they wouldn't necessarily have a corporate connection, so they wouldn't necessarily pay those fees. I'm not saying they should, I'm just asking the questions.
Mr. Chairman, thank you. Senator Case, that is correct. Trusts in Wyoming are not required to register with any governmental entity, and that is regardless of who the trustee is. So if I form a trustee and I would like Betty to be my trustee, she is a Wyoming resident and she would certainly be allowed to do so. And so that is a private arrangement between me, Betty, and the beneficiaries of my trust. Other end of the spectrum, as Mr. Reimer noted, if I went to Bank of Jackson Hole or some other bank that had a trust department, asked them to be trustee of my trust. Similarly, that's a private arrangement between me, the bank, and my beneficiaries. The bank has legal obligations to my beneficiaries, but they don't have to register with a state agency. And so as a matter of public policy to date, Wyoming has not imposed any sort of registration process or fee for any trust, regardless of who the trustee is.
And if I might, thank you. I think it, Chairman Case, it is important to note the distinction between a private trust, which, as Mr. Reimer mentioned, all trusts in the 50 states are private arrangements between the parties. So that is the trust, the arrangement. The private trust company is a type of trustee. And so it's very easy in our experience for the layman to conflate those, but it's important to know, are we discussing the trustee or the actual trust itself?
Yeah, and Mr. Chairman, I really do appreciate that. And it's 101 and need to be really clear about that. So the private trust companies, that's the fees that we're really interested, not the fees for people's trusts. Yeah. And they do not have to necessarily have a corporate connection or not. Is that correct? So they don't have to register as a corporation or any type of business entity, or they do? Just help me with that.
Yeah, go ahead.
Yeah. Mr. Chairman, thank you. Senator Case, any Wyoming private trust company must register with the Secretary of State when they form their entity, either as a corporation or an LLC.
That's the only way.
Correct. The banking statutes that Mr. Reimer mentioned specifically require that in order to serve as a private trust company, you must either organize as a corporation or a limited liability company. And then if you choose to pursue regulation by the Division of Banking, either because you choose to charter as a public trust company, i.e. such as what our chartered public trust company is, in order to be able to do business with the general public, or you choose to charter as a family trust company where you're only limited to serving certain family members and designated relatives, then you would still have a supervisory fee. So there is a fee charged when you apply. It's a charter application fee. And then there's an annual supervisory fee. And then there are additional fees that are charged anytime you have an examination.
Can I go just a little bit further?
Yeah.
Thank you. This is extremely helpful and I appreciate it. And I feel kind of amateurish here a little bit. I guess we're up against the professionals. So a private trust company that is registered with as a business entity, let's just call them a LLC with the state of Wyoming. When they have their filing their annual reports and they have to pay their annual taxes or fee, however you want to say it, to the Secretary of State, that fee is based on the trust company's assets. That is not the assets that the trust company manages because they don't belong. I assume they don't belong to that trust company. Is that correct? So you pay the fee based on the building that you have, whatever your assets, but you're not paying the fee based on the billions that you're managing or hundreds of dollars you're managing. Do I have that right?
That is correct.
Okay, thank you.
Anybody else? Senator?
No, Mr. Chairman, Senator Case already beat me to the punch.
Okay,
If
gotcha.
you recall, I asked Mr. Reamer about the fee issues. So I'll wait till the Division of Banking gets up and speaks to us, but I just like to know what the various fees are, examination, supervision, whatever, and whether they need to be changed.
It's all about the money.
Okay, any other questions? Representative Sweeney has a question.
Thank you, Mr. Chairman. So trying to drill down just a hair further, then there's really no way to monetize anything within the trust itself. Because you're collecting fees for managing and putting the trust together. So it's really, and it's not tax avoidance, I get that. But there's really, I guess, no way to monetize any of that unless there's a distribution out of the trust, which would go to a person or whatever. And then as Mr. Reimer kind of discussed, then if there's an income tax or whatever in whatever jurisdiction, not Wyoming, that's how that would be treated. Am I understanding that correctly?
Wants to.
Thank you, Mr.
Oh.
Chairman. Representative Sweeney. I'm Amber News. I'm a director at Wyoming Trust Association and also a partner at MHP. We're a 80-person CPA firm located in Cheyenne. So thank you for the question. Representative Sweeney, I think if I understand you correctly, if there's a distribution out of the trust, that could impact taxation for the beneficiary. But again, because Wyoming does not have a state income tax, there would be no revenue generation for the state from any such distributions from the trust. Hopefully I answered that in a helpful way.
How about, we're not interested. I mean, we're not pursuing any kind of income tax. It's one of the beautiful things of Wyoming, really. I mean, got great schools and we've got no income tax. And we do have we're talking about other fees, but we do have sales tax, property tax, one of our two legs, along with severance tax, which you could argue is kind of a gross receipts tax on minerals. Or in some of these other jurisdictions, Nevada, South Dakota, particularly, do they, like, attorney fees in Wyoming are, that's an exemption from sales tax. We only tax about, I don't know, 58, 60 services, where South Dakota is like 160 some services they tax. What's the experience in South Dakota? Maybe you don't know. I mean, do they tax legal fees? Because we talk about all the work that's generated, and that's wonderful. We want to grow that, but that's my question, just quickly off. They might know that.
Chairman Case, Representative. I do not know the answer to whether South Dakota charges for legal fees. What we can say generally is that all of the top trust jurisdictions are very similar in terms of tax and trust laws, because otherwise they simply wouldn't remain competitive.
Roscoe has a question. Go ahead.
Thank you, Mr. Speaker. Any of you three, do all the competitive states offering these trusts have income taxes? Do any of these other states have income tax? Thank you.
Thank you, Mr. Chairman. Representative Roscoe, by and large, they do not. So South Dakota, Nevada, Wyoming, Alaska, New Hampshire, the other leading trust jurisdictions do not impose an income tax on trusts. I would note that Delaware imposes a personal income tax on their residents, but that they do not impose income tax on trusts there unless they have resident beneficiaries who also live in Delaware. So Delaware ends up being a great place to have a trust unless you are a Delaware resident.
Any other questions? Very good. Well, we appreciate you. And again, it would be possible to hang around through the end of this because if we have public comment, it'd be great. Appreciate the education piece. Thank you.
Thank you very much, Mr. Chairman, for the opportunity, and committee members.
Okay, members on the, and I, next up is Mr. Buckley, and I think he is, you can admit him, Mr. Buckley, if you can you hear us?
I can, Mr. Chairman, and can you hear me as well?
We can, yes. Welcome, and the floor is yours.
Thank you, Mr. Chairman and members of the committee. I very much appreciate the chance to speak with you today, and I apologize I can't be there with you in person. My name is Lucas Buckley. I'm a partner at Hathaway & Coons LLP. We're a Wyoming law firm that served Wyoming for about 50 years, based out of Cheyenne. A significant part of our firm's practice and my practice involves estate planning and wealth preservation matters, business formation and advising in the burgeoning digital asset space here in Wyoming. So some of the issues that are before the committee are near and dear to my heart and some folks at my firm's heart, as well as our clients. I absolutely agree with Mr. Reimer and the folks at the Wyoming Trust Association, both in their testimony here today, as well as their submitted thoughts and analysis. My goal is not to retread any of that ground, but I would absolutely be happy to answer any follow-along questions if anyone thinks of any relating to their testimony or mine. I can tell the committee that in my experience, we do not have an influx of bad actors in Wyoming flocking here to take advantage of what I see really are not nefarious policies or policies prone to abuse, but what I think are wise and forward-thinking privacy, wealth preservation, and business-friendly statutes and policies. I would certainly disagree with any assertion by the Washington Post or any others that there's some rampant tax evasion occurring through trusts administered by private or public trust companies in Wyoming, based on my experience. One thing that I'm asked consistently in my practice, both on the trust side and on the business side, is, why Wyoming? An individual in pick a state, New York, Ohio, Texas, why should they incorporate in Wyoming, organize in Wyoming, or why should they set up a trust in Wyoming? And what strikes me is a real issue before this committee is the answer to that question, which I think really is a broad policy issue. Ever since Wyoming created the first LLC statute in 1977, and I think absolutely continuing to today, the legislatures appeared to want to create a business and trust-friendly environment that's attractive to startups, midlife businesses, late-stage businesses, as well as high net worth families, or others who are looking to do some, what I would say is wise planning for their business or for their estate and the wealth that they've accumulated. I think a lot of folks who don't understand that have probably never set foot in Wyoming and certainly don't understand the ethos of Wyomingites. The ideology that makes us very friendly for others outside of the state as well as inside the state is absolutely reflected in the tax structure that we have in our trust statutes. And those are especially including, as Mr. Reimer talked about, the asset protection trusts, other trusts we'd call non-grantor trusts, which just means that a trust is taxed here in Wyoming, I guess tax in quotes, as opposed to a local state or a foreign jurisdiction, with the idea that then it can avoid some taxes that might be paid in New York, for instance, through Wyoming's tax laws. And I say avoid, and probably it's not a great word because it has a pejorative thought to it, but really it's tax planning. There's nothing going on here that is illegal or improper or is not absolutely allowed under the law of Wyoming, the federal tax laws, or even the laws of a different jurisdiction. As Mr. Reimer mentioned, if funds are flowing through California, New York, they're going to be taxed in California and New York. I think additionally, we've got a very, very favorable LLC statute, as well as a very favorable scheme around the growing digital asset framework. In that vein, my firm and lawyers at our firm do a significant amount of work in the digital asset space, and I did want to give that special mention. I think taking a quick step or a not fully thought through step on these so-called cowboy cocktail issues could quickly undo a lot of the very good work that the legislature has done in the past 5 years to make Wyoming a leader in the digital asset space. For instance, Wyoming's digital asset lien cleansing statute has, in my experience and based on the clients I deal with, led to investors in crypto or digital assets looking to come to Wyoming to domicile their digital assets and ensure that they can cleanse any liens that might be asserted by others on those assets. To do so, that requires custodians for those assets, including the very trust companies who the association represents and who have, as Mr. Reimer noted, grown in number pretty significantly over the past 1 to 2 decades. And these are companies that absolutely could be in the crosshairs of any kind of reactionary legislation based on fair concerns, absolutely, that are raised by the Washington Post or issues with Russian oligarchs. But I think the critical question is whether there's a problem that's going to be solved there. Relating to digital assets, we've seen a great deal of interest in high net worth individuals who are invested heavily maybe in digital assets and specifically want to protect those assets through our Wyoming Asset Protection Trusts. Similarly, we've seen a significant amount of DAO LLCs being created in Wyoming that if we increase reporting requirements or tax requirements, we have created the first DAO LLC statute, but those businesses will go to Delaware or Vermont or other places where they think they can get almost the same treatment. And you weigh the value of having a very clear regulatory scheme for our DAO LLCs against taxation, they're going to go other places. And I don't have much doubt of that. So it seems to me that the question is whether Wyoming should abandon a favorable and very privacy centric, and to follow along to the association's comments, I think that is right. This isn't secrecy. This is an interest in privacy and an interest in not having others see our business. And there's nothing wrong with that. I think it's a very human emotion and a very human thought. But do we want to trade that privacy-centric business and trust paradigm for regulation, oversight, or taxation? And these, to me, and as questions are raised about the Cowboy Cocktail by the Washington Post, these really seem to be solutions that are in search of a problem here in Wyoming. And I think making reactionary changes based on, sensationalized reporting really ignores the fact that we don't have an issue here in Wyoming. So the purpose of the committee's hearings, or maybe the outcome, is going to be whether or not something should be done to avoid fraud or financial crimes that simply don't exist or haven't been shown to exist in Wyoming. And I think equally importantly is there are federal guardrails in place. And if further regulation is needed, I would say that needs to come at the federal level. Wyoming, I don't believe, is in a position to, again, regulate Russian oligarchs or try to, ferret out bad actors in the financial system. Those really are issues at the federal level. And I think if that regulation comes at the state level, whether in the form of oversight, reporting, or taxation, it's going to be harder to do business in Wyoming. And the legislature could look at undoing decades of business and trust-friendly work that has proven to be a benefit for Wyoming. And again, doing so without a clear mandate or reason or problem to be solved, to me, and I know to my clients, would be incredibly detrimental. And not to belabor the point that's already been made, but as noted by others, these folks will go away. And so it seems to me there's two unrelated largely issues on the table. One, are we worried about tax fraud, financial crimes, or bad actors coming to Wyoming? And again, I think federal regulations certainly resolve that. Mr. Reimer's absolutely correct about the Corporate Transparency Act and the reporting requirements that are going to come about through that. Also true that our financial system is heavily regulated, and the onboards or on-ramps to use of United States funds, including digital assets or cryptocurrency, are very well regulated. And again, I don't see as a place where we've got significant amounts of trouble. So one, are we trying to avoid fraud and financial crimes that nobody has really found to exist? Or two, is this just a question about taxation? And of course, that's a fair question as well. But I think it's exactly true that these trusts and businesses would simply abandon Wyoming for more permissive jurisdictions. And whether we're talking about 1% tax, a 0.01% tax, or a 50% tax, any mathematical percentage tax of zero is going to be zero. And so I don't know that there's a real way to, if that's even the committee's intention or desire, to monetize some of these assets. I certainly, though, applaud the committee on taking up this topic. It's my hope and belief that instead of finding that there's some defect in our structure, what we'll really see is the privacy and tax advantages here in Wyoming are a feature of our ideologies and policies, not a flaw. And again, I absolutely appreciate the committee's time today and would welcome any questions that I may be able to answer.
Okay, Representative Baker has a question.
Thank you, Mr. Chairman. And I'm just looking for a brief answer, but so have you seen requests for Dow-owned trusts?
Mr. Chairman and Representative Baker, I suppose I anticipated that question from earlier. So what I have seen principally in the Dow space specifically is relatively unrelated to trusts, but there is some potential overlap. So I haven't seen a lot of what I think a typical structure would be some sort of irrevocable or asset protection trust set up with a trustee, and theoretically that trust wants to create and own the membership or a portion of the membership interest in a Dow LLC. Again, I haven't seen a lot of that, although I don't know that it would be a bad structure, because I think the membership in Dow LLCs is kind of an open issue, and it was addressed to some extent by the legislature last session. But the idea then would be you've got this holding company in the form of a trust, and I mix those terms a bit, but holding and ultimately owning a Dow LLC, which then has some sort of token structure to allow distributed governance among others who have financial or governance interests in the LLC. Again, not a structure that's been incredibly typical, but we are very much in the early stages of how these Dow LLCs are going to work. And I don't think that honestly would be a bad structure. And maybe to the point of some of the issues before the committee, I certainly don't think it would be some sort of fraudulent or secretive structure that would be improper. And I apologize, you asked for a quick answer and I'm giving a longer one. But one of the nice things I think we have seen over the years, digital assets were thought to be the haven of hackers and bad actors. But what we really have seen is that keeping everything native on the blockchain, including ownership or interest in Dow LLCs, you can't hide. You can be pseudonymous, but you can absolutely be found. And I think that is happening.
Okay, very good. Any other questions? Starting Senator Schuler and then Representative Sweeney.
Thank you, Mr. Chairman. Just a quick question for Mr. Buckley, and it's more out of curiosity than anything else, but do you see any kind of a trend where some of these folks that set up the asset protection trust or an LLC, then taking those and moving those on to offshore kinds of situations? Have you seen any kind of a trend that way?
Mr. Chairman, I apologize. Mr. Chairman and Senator Schuler, thank you for the question. I have not seen a lot of that. And honestly, I think one of, again, the features of what we have set up in Wyoming is that we have a federal regulatory structure that it makes it, I think, very hard to commit financial crimes. In years past, people just said, well, why don't you set up a Cayman Islands or offshore entity and you hide all of your assets? What we see is people bringing their assets to Wyoming through regulated trust companies, LLCs, and other methods that I think increases the visibility on a lot of the actions, because again, we've got such great bank secrecy laws. FinCEN is designed to ferret these activities out. So I see most people coming to Wyoming and staying. And from really a bad actor perspective, I think that's a good thing. I think it helps with federal oversight of some of those funds.
Thank you.
Okay, very good. Representative Sweeney.
Thank you, Mr. Chairman. So thank you for, this has been a fascinating discussion. And back to your comment about fraud or taxation, I really appreciate those two comments. And in the back of my mind, I thought possibly there was fraud. But on the taxation issue, of course, in my mind, I'm trying to monetize somehow some of these assets, which doesn't seem to be possible. So except possibly some fees and looking at that. So when you brought up digital assets, I guess where my question lays is a few years ago when we worked on the blockchain and the series LLCs, do you feel in the series LLCs, if those are turned into a trust mechanism, did we give the farm away with basically on the series LLCs, you've got the mother LLC, but then we really don't monetize the other 100 plus in the series, in my estimation. Is that, did we give the farm away?
Go ahead.
Mr. Chairman and Representative Sweeney, thank you for the question. One guy's opinion, I suppose, in practicing in the area, I don't see it that way. I think through the series LLC, you still got your annual reporting requirements. And so whether I pick a number, $1 million in assets into a typical LLC, or I put them into 5 different series under my series LLC at 200,000 a piece. From a monetization standpoint and a tax standpoint, I believe that those are all going to be treated the same. And Ms. Wheeler may be able to speak to that more, and I will happily say I'm wrong if she tells me I'm wrong. However, I don't see us having given anything away. And if, in a related question, I suppose, if the issue is, well, are we not taxing assets held by a trust, but we are taxing assets held by an LLC, and couldn't you just transition from an LLC to a trust? What I see is the most typical structure, and again, the association may be able to speak to this as well, is you would often have a public trust company or even a private trust company acting as a trustee of a trust, but those assets under the trust are still going to be placed in LLCs. And the reason for that is that if we're talking about an LLC or a liability on an asset, I own an ice cream shop and I don't know, any number of bad things happen. If that's not in an LLC, then the trust is going to get sued. The liability extends to all trust assets, whereas typically we would put that asset in an LLC to protect against liability outside of the LLC. So I think they both still get used in a very complementary way. And again, I don't see any of that as being nefarious in any way.
Any other? I'm moving this way. I'm going to stop here and then I'm going to keep moving. I just have just to kind of summarize again for the committee and the folks who are listening. So Wyoming, along with the other give me the top 5 states that we got to make sure we stay competitive with. I mean, it's Wyoming, South Dakota, Nevada. Go ahead, add to that and just tell us. Again, reaffirm for us.
Thank you, Mr. Chairman and Representative Harshman. Absolutely, I think that's correct. Wyoming, South Dakota, Nevada, Alaska, and Delaware, and some in Vermont, I would expect are the top states that we're really talking about competing with, and I think that's exactly right.
And then I heard Tennessee out there too at one point. Sometime today. What do you?
And Mr. Chair and Representative Harshman, I'm not as familiar with Tennessee's laws. I think as Mr. Reimer alluded to, it certainly is true that oftentimes just idiosyncratic issues relating to somebody's wealth may make them look at states that are a little less, at the top of the pile for general asset protection or trust work. So Tennessee may be up there. I haven't had a lot of experience with Tennessee trusts.
Okay, very good. And then, okay, so yeah, that's great. Okay, any other questions for the committee? Representative Yen.
Thank you, Mr. Chairman. So the tax issue, I don't think it's that big to me. I think if a very rich person who lives in a state that has a higher income tax, all they have to do is buy a property in Jackson Hole and they claim it as their primary residence, and then they don't have to pay their state's income tax anymore. And then raise my property tax as a result. So that's not my focus. My focus is ultimately, what happened in the Pandora Papers is all about the foreign national question. And so the question that I gave to Mr. Reimer, I do want to focus on you as well. If a foreign national decided to work with someone in Wyoming to set up a trust and choose to use a bank that doesn't fit CRS compliance, because is that a requirement? Could they be able to do that? Is it possible for foreign nationals to still protect money from their own from their own home government through a Wyoming trust? Thank you, Mr. Chairman.
Go ahead.
Mr. Chairman and Representative Yen, thank you for the question. I will say that I have seen, and this isn't quite a direct answer, but I've certainly seen folks and talked to folks who get very concerned that the country they live in, the banking system or the government can't be trusted, and they look to, which again I don't think was true even a decade or two ago, they look to domesticate assets in the U.S., which tends to have the heaviest regulatory structure in the world, which I think is a difference. And so there's one part to that I'd say there's some value to allowing loosely used some investment and some domestication of assets. Now, there's another very fair concern, and that's can people, bad actors in other states, hide their assets in the U.S. now from their own governments? And one, not to be too glib about it, but the foreign government needs to make sure they're tracking that. Two, I think from a practical perspective, Mr. Reimer is absolutely right that that's not happening often, because we do, from a public perspective, we have a financial system that I think is good. I don't know what anyone on the panel's net worth is, nor should I, but our government can certainly find out and would get red flags from nefarious or questionable actions, and I think that's true with foreign nationals as well. So could it happen? I mean, I think that probably is based on the strength of the foreign jurisdiction. Does it practically happen that we are hiding assets? I don't see it.
Okay, Representative Roscoe has a question.
Thank you, Mr. Speaker. This question may have been answered already, but I was just curious, how many states have unregulated private trust now?
And thank you, Mr. Chairman and Representative Roscoe. I could not definitively answer that. It did sound like Mr. Reimer may have a little bit of information on that. As he noted, I think it's hard to, well, we could probably put a number on it, but that's a little bit of a subset of probably the 18 that he mentioned. How many could possibly have unregulated private trust companies? somewhere less than the 18, I assume, and I don't have a specific number though.
Okay, well, I think we've exhausted questions at this point. Really appreciate your information. It's been a great learning experience this morning. So, and if you can, it'd be great. You're welcome to stay, and as we move through this process and have more questions. So thank
Absolutely.
you. And if you have to go, we understand too if you can't. So again, thank you very much.
I will be available, and thank you very much for the time.
Okay. Okay, next on our agenda, we have Mr. Garul is up. If we can promote him.
Thank you, Mr.
I want to
Chairman.
make sure, can you introduce yourself? I want to make sure we say your name right.
Thank you, Mr. Chairman. My name is Ryan Garul. So you got my name right. That's absolutely correct.
I think we got it. Yeah, very good. Okay, and then who you represent, and then the floor is yours. Thanks for joining us.
All right. Thank you, gentlemen. Good morning, and thank you, Chairman Case, Co-Chairman Harshman, and the members of the Joint Revenue Committee for having me. I do wish I was able to come to Wyoming today. I am a son of the Rocky Mountain region and always like an excuse to get out there, but unfortunately couldn't swing it. Next time for sure. For the record, my name is Ryan Garul, and I am here as the Policy Director of the Financial Accountability and Corporate Transparency, or FAT Coalition, a broad, nonpartisan alliance of over 100 member groups dedicated to standing up structural reforms that address vulnerabilities in the U.S. financial system related to tax dodging, corruption, and criminal or other illicit financial flows. I am here because the equality state is engaged in a race with a limited handful of jurisdictions across the globe to attract capital based on financial secrecy. An unfortunate byproduct of this race is that Wyoming has attracted and protected capital from people who threaten our national security and undermine the stability of our financial and Main Street markets, including by using complex tax structures to launder ill-gotten monies and hide assets. Secrecy afforded under Wyoming laws appeals to actors like Russian oligarch Igor Makarov. He protects portions of his immense fortune via Wyoming Trust, managed by an unregulated Wyoming private trust company. In case anyone assumes secrecy and avoiding public accountability was not at least partially Mr. Makarov's aim, it should be noted that layered into Mr. Makarov's trusts are companies registered and assets titled in the more readily recognized offshore tax haven of the British Virgin Islands, creating a Russian nesting doll of secrecy. We are not talking about working class families putting their homes in simple trusts to avoid probate. Rather, we understand that trust companies in Wyoming hold at least $31.5 billion worth of assets in trust, close to the GDP for the entire state. Wyoming citizens might ask why there is so much desire to attract foreign capital if doing so might fail to turn into measurable economic gains for local communities. This morning, I will discuss first the growing evidence that the U.S. is a singular financial secrecy jurisdiction, attracting problematic capital and potentially facilitating tax evasion, sanctions evasion, or similar harms. Second, how Wyoming's unique laws inadvertently contribute to this problem. Third, certain bipartisan reforms currently being implemented or considered to address this harm. And fourth, reforms Wyoming might consider to ensure that it attracts capital that is consistent with its core values as the equality state. We know from the Pandora Papers that U.S. trusts and Wyoming trusts in particular are being heavily abused in a way that erodes the U.S. and our allies' tax base and undermines national security. The financial secrecy offered by the U.S. and our allies have also previously enriched and empowered potentially adversarial regimes. We should be clear, however, that the Pandora Papers are just one leak of data and should not be viewed as indicative of the entire universe of problematic anonymous U.S. or Wyoming investment by corrupt or criminal actors. Rather, the Pandora Papers serve as an indictment on the financial secrecy afforded by U.S. laws, including those in Wyoming. The risks that financial secrecy pose are why bipartisan efforts in Congress have prioritized bringing greater transparency to U.S. legal entities in the fight against corruption. Anonymous shell companies in the U.S. pose one of the biggest vulnerabilities to the U.S. financial system. According to an analysis by the Global Financial Integrity, one of our ally members, until recently, in all 50 states, more personal information is needed to obtain a library card than to establish a legal entity that can be used to facilitate tax evasion, money laundering, fraud, and corruption. And as international tax and financial transparency measures have begun to peel back secrecy in traditional offshore tax havens, cross-border deposits in U.S. financial institutions, often held in trust or via other anonymous legal vehicles, have substantially increased. Unfortunately, Wyoming law lures the wealth of international bad actors through a potent combination of secrecy, durability, asset protection, and favorable tax treatment for out-of-state tax individuals with no intention of meaningfully investing in Wyoming. Additionally, Wyoming is one of only a handful of states that allow unregulated private trust companies. Historically, trusts served as legal arrangements where legal title to his assets were transferred to a third-party trustee to manage assets on behalf of identified beneficiaries for a limited number of years. Through Wyoming's unregulated private trust companies, however, individuals that might transfer assets into trust and those that get to benefit from trust assets, who may be the same individuals, are able to continue to effectively control trust assets. With careful planning, unregulated Wyoming private trust companies can currently exist completely outside of Wyoming or federal banking or securities laws. Federal customer due diligence rules that might apply for financial institutions may not apply to identify trust grantors, protectors, or beneficiaries. And the U.S. banking system may further be entirely circumvented in some cases. Simply put, Wyoming law enables investment that exists outside of any meaningful rules and to prevent corruption, money laundering, terrorist financing, and similar harms. As an unintended consequence, Wyoming law can therefore frustrate efforts to keep U.S. markets clean, transparent, and well-functioning, as well as to frustrate key national security measures such as targeted sanctions. Wyoming's relationship with the LLC is one for the history books. Wyoming was the first state to introduce the LLC in 1977 and has followed other states in making LLCs more secretive. Recently, Wyoming has created the Decentralized Autonomous Organization, or DAO, Limited Liability Company. Management of these organizations may be conducted by members or algorithmically. And there appears to be a tremendous amount of flexibility in the ways that membership interests may be held, such as via digital tokens, and in the ways that DAO or DAO LLCs may be operated. It is less clear that DAO LLCs must be capable of knowing who owns them, however. Last year, Congress finally took steps to address threats posed by anonymous legal entities and passed the Bipartisan Corporate Transparency Act on January 1st, 2021, a measure that requires corporations, LLCs, and other similar entities formed or registering to do business in any state by filing with the Secretary of State or similar office to disclose their true natural owner. The information is to be housed at a secure directory maintained at Treasury's Financial Crimes Enforcement Network, or FinCEN. The CTA also banned bearer share companies, or companies that evidence ownership by issuing certificates in bearer form, to ensure that companies cannot claim total ignorance to their ownership, including to contravene the CTA's rules. Doing so also cracks down on an entity structure that has time and time again been linked to corruption, money laundering, terrorist financing, and other illicit financial flows. The FACT Coalition previously filed comments on best practices for establishing the CTA's secure directory in response to FinCEN's proposed first rulemaking, including addressing who should file disclosures, when they should file, what information they should provide, and how certain exemptions should be handled. FinCEN has announced that it plans to issue a second proposed rulemaking addressing access to the directory, including by state, tribal, and local law enforcement agencies. FACT has advocated for uncomplicated and complete access for authorized users, including the state of Wyoming. Based on current practices, as the other testifiers have noted, the CTA should bring some well-tailored transparency to unregulated private trust companies organized as Wyoming LLCs or corporations, and in doing so, bring some transparency to certain Wyoming trust structures that are so attractive currently to international bad actors. Yet, the application of the CTA to certain trusts and Wyoming DAO LLCs remains unclear. For those Wyoming trusts that do not file at all in connection with formation or other key events, the CTA may apply to varying degrees based on final rules when promulgated. For DAO LLCs, it is clear that these organizations must be able to identify their true owners in real time. However, as mentioned, Wyoming law currently is a little unclear on this point. Wyoming is taking an encouraging first step today by seeking to better understand the potentially unintended consequences of its own laws. We encourage Wyoming to consider taking the following steps. Consider leveraging bipartisan financial and federal reforms to ensure that Wyoming has the information it needs to determine true beneficial ownership of all trusts, LLCs, corporations, or other arrangements, associations, or entities formed, governed, operating, or investing in the state. For example, the state of Alaska, historically seen as competing with Wyoming, as we just discussed, is considering legislation that might bring greater transparency to its trust and real estate sectors without imposing meaningful additional burdens on these sectors. These reforms might further advance the bipartisan CTA, as well as shore up certain gaps in information or access questions relating to Wyoming's real-time use of related information that remains subject to a final rulemaking. Consider making clear that DAO LLCs must keep track in real time of any holder and beneficial owner of DAO LLC membership interests to avoid any possibility that DAO LLCs might contravene with the CTA's prohibition of bearer share entities and international best practices meant to deter terrorism financing and other risks. And encourage the State Legislative Services Office to consider further risks posed by effective anonymity afforded by the Wyoming Trust and Limited Liability Company industries, and ways that the state might advance greater transparency to encourage investment in line with Wyoming priorities. In conclusion, our system of federalism is made better when states innovate in ways that reinforce our democracy, our open and transparent markets, and our national security. The opposite is true when states compete for investment through financial secrecy, which may have unintended consequences, such as to allow potentially corrupt, illicit, or criminal capital to find a safe haven. This legislative body, just like Congress, has an important role to play in ensuring that the Wyoming and U.S. financial systems are not vehicles for bad actors. I want to thank you again for inviting FACT to participate in this important process, and I look forward to our conversation.
Okay, thank you. Any questions by the committee? Representative Henderson has a question.
Thank you, Mr. Chairman. I asked a question earlier related to the value of our trust sector in Wyoming. One of the things that strikes me is the value, and I have some personal experience with the family trust, is that there's a distinction between the family, the individual, private citizen, and the mega wealthy LLC, corporate entity, or however that's structured. So the key thing in all of this is who has custody, who's the custodian of the asset involved. Have you seen anything in your work or your organization related to those states that currently have custodian fees? You know, it's like if you bring an asset to, I'll just use a simple one. You take your vehicle to the resort, and there's a parking valet service, and you park, and it's customary that you pay a modest fee for that service. Have you seen anything in that in terms of the states that regulate or don't regulate trust where custodial fees are in play?
Mr. Garula, go ahead.
Thank you, Mr. Chair. Representative, I have not seen that in our practice. We do at the FACT Coalition focus more on the transparency-based reforms and reporting as it might relate to anti-money laundering concerns or federal tax concerns. So I can't say that I've seen that, but I'd be happy to reach out within our network and see if anybody has, given our broad, large alliance, as I mentioned.
Mr. Co-Chair has a question. Senator Case.
Well, I'm not entirely sure it's a well thought out question, but I do appreciate the testimony of everybody today, and I appreciate connecting with Mr. Garula and having him come and talk about it. But it's apparent we have two widely different thoughts here, and I'm sure you were able, Mr. Garula, to listen to the earlier testimony, and which is largely it's very competitive, competent, well done in Wyoming. There aren't a lot of problems. You have quite the opposite, and we, in a way, it comes to my mind is we got to figure out a way to move forward. We definitely respect your position and the position of the others that spoke. We've got to figure out a way to figure this out and move forward. And so I'd be open to suggestions from you on what further steps the committee needs to do to really understand it and to realize there's a problem, because you're the only one that we've heard from today that's telling us there's a problem. And believe me, that's not a criticism. That's just what we've heard so far. And so we've got to work that out. And we could use some help doing that. We've got other folks going to testify. We've got a couple of our elected officials' offices, and we've got our division of banking. And then there'll be some general public comment, I assume. And then I don't know how this is going to play out. I think probably until your testimony, it seemed like we were done. It looks like it was going to be okay. So I'm open to suggestions, sir, and I appreciate it. And thanks for being with us today.
Okay, any final comments on that, Mr. Guru?
Thank you, Mr. Chairman. Thank you, Senator Case. Broadly speaking, the FAT Coalition recognizes that the U.S. financial system is an attractive one, and that the states should be incentivized to make the U.S. financial system an attractive one. We aren't against the financial innovation that is consistent with the well-tailored anti-money laundering rules, countering the financing of terrorism rules, and other rules that are meant to protect our financial system. We are encouraging of those types of innovations that are consistent with those reforms and those rules, but at the same time, then bring capital to the United States exactly that is aligned with the values that the states might seek to encourage, for example. So from the perspective of the other testifying members today, I can't necessarily speak to their own experiences, which it sounds like most of them were testifying from their own experiences. But I would note that it does seem like we were invited here today, and this hearing was in part called based on well-respected international journalism effort, which revealed that there were some, in fact, unsavory characters who have invested through Wyoming Trust. And from that perspective, I do think that it makes sense for this body and the state of Wyoming to continue to reflect on what this means in terms of how they want to encourage investment in the state of Wyoming itself. From that perspective, our recommendations again are that Wyoming is well positioned to be a leader in more transparency, at the same time still attract capital. There is a lot Wyoming has to offer in terms of its natural resources and other economic activity. But at the same time, Wyoming certainly is in a strong position based on this hearing today to continue to consider seriously reforms that other states are considering, efforts that can further financial reforms meant to bring greater transparency to the U.S. financial system, as well as additional research that the state of Wyoming itself might consider doing. For example, one thing we didn't hear today, and that was asked several times, was how much of that capital that's brought to the Wyoming Trust might be foreign offshore capital. I think that's something this body should probably do something to figure out. And I think that you have maybe the research tools to do that. It might be a good starting place. But those are just my high-level suggestions, and I'd be happy to continue to work with this body and to continue to work with the other testifying members to direct policy that makes the most sense to shore up the U.S. financial system and the Wyoming financial system.
Okay, thank you. Appreciate it. We have another question, Representative Sweeney.
Thank you, Mr. Chairman. So in your testimony, are you taking broad strokes based upon any particular research? I mean, can you actually, your organization, point to something other than the article that has kind of been disputed? Can your organization actually factually point to anything that our regulated trust professionals have done wrong, or our banking institutions have done wrong? Or is it merely broad strokes that you're talking about in regards to the article? Because I've not really heard anything in particular that you're offering today.
Mr. Guru.
Thank you, Mr. Chairman. Thank you, Representative Sweeney. I would note that the journalism that brought us here today, I think, does have direct, tangible examples of potential vulnerabilities in the Wyoming system. And those vulnerabilities in particular were identified outside of the specific spaces that you're referring to, which were the regulated trust companies, the regulated trust providers, and the Wyoming banks. And as I mentioned, it is very possible structurally, based on Wyoming law and other laws in other states as well, but Wyoming certainly being one of the most competitive jurisdictions, depending on how you define competitive, it is very possible to avoid the U.S. banking and securities laws that would otherwise help to root out or flesh out who exactly might be investing in the U.S. financial system. And creating that shield of secrecy through Wyoming law, I don't believe is probably a desirable effect for Wyoming itself. The other thing that I would note, Mr. Representative, is our work is largely at the federal level. And our understanding, based on the most recent Treasury analysis, is that 2% of the US GDP, that amount, or an amount equal to 2% of the US GDP, rather, sorry, represents the amount of probably illicit financial flows that fly through the US financial system every year. That is a staggering number, close to almost $500 billion a year. And we know that that happens not necessarily because of good people at regulated banking institutions and otherwise turning a blind eye, but because of actual giant gaping holes in our anti-money laundering system. And one of those relates to trust. And Wyoming is a jurisdiction that competes on the basis of its trust law and specifically on the secrecy that it provides. And as a result, that might have beneficial results to the Wyoming trust sector itself, or certain service providers within it, not even all providers. But those benefits might not be permeating to the state itself and might in fact be accruing larger harms, such as relating to geopolitical risk worldwide, if we are allowing the US financial system to enrich or enable potential foreign adversaries.
Members, any other questions? Okay, I think we've exhausted questions for now. We sure appreciate your time and preparation and your information. And going to continue this.
Stand by.
And if you can, like we've said to others, if you're available, certainly welcome and love to have you stay with us to the end of this discussion as we move forward. Okay.
It'd be a pleasure. Thank you.
Okay, thank you. Okay, members, before we go to next up is going to be our treasurer's office. Our treasurer is here today, and then Secretary of State and Division of Banking. So we have three more left on the agenda. I just want to take a real short break. So you see where that clock's at. Like to be back here in about 6-7 minutes. So about 25 till. Thank you. So we'll stand at ease for a few minutes. Okay. We are back live and back at it. Next on our agenda, we're joined today by Wyoming State Treasurer, Mr. Treasurer Meyer. Welcome to the committee. Go ahead and quickly introduce yourself, former senator. And
Thank you. Thank you. I'm Kurt Meyer. I'm your state treasurer. And the reason I'm here is because I was a former senator, I guess, because some people reached out to me. I guess in my previous life there, Kayla and I and some folks worked on this issue before, and we tightened it up a little bit a few years ago when Secretary of State Ed Murray was trying to go, I guess address this same issue. And I think Kale came up with a good compromise at that time, and it's worked, I think, reasonably well. And I think I'd like to start off by saying I think that Wyoming leading the way in LLCs has really led the way for small businesses to thrive and really excel in Wyoming and across the United States with this corporate structure, because people need that protection. And whatever we do, or whatever you guys choose to do or not to do, we want to make sure that we maintain this corporate structure, the ease of people being able to basically get into the structure, protect their assets, protect their liabilities, protect their families when they get out there and they try to make, Wyoming go back to work again, and the country go back to work. And we really offered this across the world. And I think that's amazing accomplishment for this state to provide that same type of structure and that same type of security really across the globe. So I don't think there's things that we want to make sure we leave alone, but I think there's basically some rooms that we can walk into that are going to give us, I think, a little bit more, security from the standpoint that these things that have possibly happened. I know the last speaker talked about a Russian oligarch that actually was in Wyoming. And so, I think there are some specific examples. I heard on the news the other day that Iran is getting around all of their sanctions because they've got 26 shell companies across the world, and nobody knows where their money is. They're in shell companies. Not to say that any of them are in Wyoming, but they're essentially effectively bypassing the sanctions that the United States and other countries have on them because of their ability to have shell companies and do business as usual almost. So those are the things that I think that are before us. They're big challenges. There's global challenges, and Wyoming really is on that stage as we are, because we're always and have always been, I think, leaders in the LLC structure. I think there are some things that I think that we can do, and I think a lot of them were mentioned as far as protections that are normally available in the trust process, and that's really the relying on our financial institutions and that structure, because we did a little research with some of our people that we do business with and who we invest funds with. When we asked them what type of regulations do you have as money managers when you take money in, what do you do? And it's the basic things. They find out who the person is. They find out some of these basic things as far as addresses, the type of business that they're in, and different things like that. And they check up on them every year. And banks are a little bit more, I think, they've got a bigger hurdle because, as was said earlier, is that they're really the folks that are the gatekeepers. And I tried to figure out how we could look at what we could do to be helpful in that gatekeeping process, but not interfere with the structure that we have right now. And it was brought up the differences between privacy and secrecy. And I had a person from the DEA call me, and I think I left that contact information. I don't know whether they've contacted the LSO or anything or offered any suggestions, but what they were saying is that And when you get into money laundering, what we kind of require is specific identifiers. So, and these things are necessarily would be discoverable, but they're not readily available possibly to the general public just going to the Secretary of State's website. And I think that's what we really have to look at this point in time is making sure that there is all the information that should be discoverable. So if the DEA is doing an investigation, if our banking systems are doing an investigation, that those things are there, they're available. And then from time to time, one of the things that banks actually do is that they circle back around and they really take a little bit more in-depth, I guess, action as far as understanding what actually happens and how the money's flowing in and out of their accounts. Now, I don't expect registered agents to do that, but I think that what we can do is that that the federal government can have a list that the Secretary of State's office can do a name check against, or known aliases or people that the bad actors work with. And from time to time, they could probably run through that and just do a quick data check to see if they get any hits, and then turn that over to another law enforcement body if that's the case. I don't think we need to get anything expensive, because when we drive our costs up for making this opportunity available to people that are in business, then essentially we defeat the purpose of why the LLCs were made. So I think there's a way that we can essentially do what we can to keep the bad actors out of Wyoming, not have it cost us that much. I've a little bit, and I'll go back into some things when they were talking about this federal legislation. The first thing I said is basically, I don't believe that the federal legislation has to occur in a way that it's going to usurp the state's ability to provide corporations, or basically have the federal government get into a national corporation and essentially take the states out of that process. Now, they've tried that in the insurance industry. I remember when I was on the corporations committee years ago, chairing that, they tried to usurp federal jurisdiction. And what they wanted really was the premium. That's what they wanted, was the premium tax that we have, and to put that back in the federal coffer. And so if the federal government gets too involved in regulating LLCs or any other corporate structure, they're going to figure out a way to tax it. And that's something that is, we've got to be careful with what we support. I think that we need to know who your customers are. We need to have those readily identifiable things, and they need to be discoverable. Now, exactly what they are, I can't tell you exactly what each one of those things are, but those lists are out there. Law enforcement can get that to us. We probably have most of them available right now, but we need to make sure that they're discoverable, that the Secretary of State's office has the availability to look at those. So they're one of those agencies that has the transparency to everything that's going on within the corporate structures. But there's a lot of that stuff that unless somebody has a reason to know it, I think everybody has a reasonable right for privacy. And that right is, it's in your house, because, and I think that if you have a corporation, that's almost like you're the king of that corporation too. You're the king of your house. So you have that reasonable right to privacy. So I think we have to maintain that, but it has to be discoverable in certain circumstances. So I think that's the only direction I think I can lead you guys. I think that Wyoming's done a great job. The only question I wish you would have asked some of these guys that were in the trust business is like, how much does the state get out of making a trust, which might be a few $100s? Now, how much does the other companies get out of making the trust, everybody else involved? And I would bet that we're just a very, very small amount of that, whether it's fees or whether it's taxation. So I think some of these things you have to be competitive with those states. But you don't have to offer something at below cost. And you certainly shouldn't get too excited about making sure that we are not offering things below cost.
Thank you, Mr. Treasurer. Any questions? The good treasurer. Representative Jennings, question? Okay, go ahead.
Thank you, Mr. Chairman. Mr. Treasurer, just one, just for clarification for me. So where does that line between discoverable and having to go get a warrant? I mean, there's clearly a place somewhere in there.
Mr. Treasurer.
Well, I think the functionality it would basically be is that the Secretary of State's office would have all of that information. They could look at it. And that from time to time that they would review that as far as names that were on a federal registry, of people that are basically known bad actors that are prohibited from doing business in the United States, or on a list that we as a U.S. government accepts that these are people that we don't want in our banking industry. And I think that's something that they from time to time would just basically run a data search, see if any of those people pop up. And then that would be discoverable from the standpoint of at that point in time, they could alert law enforcement officials of the proper people. So I don't think it would be, and then that would be discoverable, basically through a legal action where you would have to have a warrant for that to be, going to the next point. We wouldn't have any, I don't believe we would have any authority as a state or as a Secretary of State would have any authority to freeze any assets or to declare anything null and void or anything like that. I think that's when, just that knowledge would kick in. And, I think you'd have to see whether or not that was too much power for the Secretary of State, that if they actually knew. I guess it would be kind of like if you saw somebody, basically commit a felony, would you call the police? And that's pretty much where it is. Most of these things would probably be a felony. And so that's when you would probably report it. And these things are going to be few and far between. And unfortunately, we legislate a lot of times for that very, very small minority event that shouldn't interfere or affect anybody else. And that's where it's hard. That's where your job gets really hard. And I've been there in your seat. I know that's hard to understand that these things, you don't want these bad actors here. And the odds are that you might get 1 in 1,000 that might show up. And that old legislative thing that I heard years ago, and I don't know who originated this, but I'll have to search Google. You don't throw the baby out with the bathwater. And and really our baby is a great LLC corporate structure. We started it. It's still probably the best in the country, but we don't want to wreck that trying to fix something that occurs very, very infrequently. But at the same time, it's a global situation where I don't think that we want to have the possibility of any Iranians in here or any people that are basically on that list. You got, I think, Iran and Korea. Russia may or may not get on it. They're asking for it to be on there, but so we don't want to get into that situation because we're really protecting the reputation of the state. But we want to do it without causing any harm.
Representative Roscoe.
Thank you, Mr. Speaker. This is sort of following up on Representative Jennings' question is, and I just need something specific. So we have had someone in our trust system that we didn't want. Is that correct? A Russian, an older guy?
That's what the testimony was earlier today from the previous speaker.
I was just wondering how this would come about how he was found and what agency or what law enforcement agency was in charge of that.
That's a
Let's-
question for
hold on,
somebody
let's work
else.
Through the chair. I don't know
Yeah.
that there's been any government involved in this. This was really in a newspaper article, is my understanding, Mr. Treasurer.
In that Washington Post article, I don't believe I read anything about the specifics that was talked to about today, but I just briefly went through that.
Yeah, okay.
Yeah.
Any other questions? Okay, very good. Well, we thank you.
Okay.
And please stick around if you can through the rest of this as we got a feeling in public comment. We're gonna have a little point counterpoint. We'll see how that works out. But okay, great. Thanks. Next, we have the Deputy Secretary of State is online with us, Miss Wheeler. So if you could admit her to I think she's in the room there. Okay, we can see you. Can you hear us?
Yes, Mr. Chairman, I can. Can you hear me?
Yes, we can, loud and clear. Yes. Thank you.
Wonderful. Thank you, Mr. Chairman, members of the committee. I'm Karen Wheeler, the Deputy Secretary of State, and I'm sorry I can't be there in person today, but I truly do appreciate the opportunity to provide some information to your committee. So, Mr. Chairman, there has been some great conversation this morning regarding LLCs and trusts. So I thought it might be helpful as the office in which both of these entities are filed, if I could just provide the committee some historical statistical information, just so you can see where we are with the filings and what we do. So, Mr. Chairman, I'd like to start with LLCs, and LLCs are currently the entity of choice when forming in Wyoming. And so as I go through this, I'll be talking about fiscal years. So you have heard that Wyoming was the first state to enact the LLC law. On May 27th, 1977, Senate File 218, limited liability companies became effective. 2 months later, on July 26th of 1977, Wyoming's first LLC was formed. So in 1977, we had one LLC. Then in 1978, we more than doubled our count, and we had 3 new LLCs form, and we had 1,034 new profit corporations form. And at that time, please keep in mind the LLC was new and in Wyoming only, so people were still going with your traditional corporate structure of the corporation. So now, Mr. Chairman, I'm going to jump ahead 10 years. 1988, we had 11 new LLCs form, and then on September 1st of 1988, the IRS issued its favorable ruling for taxation for Wyoming LLCs. The next year, 1989, we saw 29 new LLCs. Then in 1990, we had 40 new LLCs. In 1991, we had 152 new LLCs formed. Then from about 2010 until 2015, we saw an average yearly growth of 12% of new LLC formations. Then after 2015, we did start to see significant growth. And so we started to look at what would have caused this growth. So in 2015, Nevada increased their filing fees. They implemented a business license fee and an annual commerce tax. Wyoming did see a migrating effect from that action. In 2016, we saw a 27% increase in LLC formations. Then in April of 2016, the Secretary of State's office introduced online filing for LLCs, profit corporations, and nonprofits. In 2017, after the implementation of that online filing, we saw a 37% increase in new LLCs being formed with our office. Over the next 3 fiscal years, we averaged a 20% increase in new LLC filings. Now, in 2021, there were 68,049 new LLC formations. That was a 31% increase over 2020. Those new formations generated revenue of $6.9 million for the state. Today, we are 10 months into fiscal year 2022, and as of yesterday, we have 68,951 new LLC formations. Now, I will tell you over the last 10 months, we averaged a little over 5,500 new formations per month of LLCs, and our projections are that for fiscal year 2022, we will exceed over 75,000 new LLC formations, which is $7.5 million in revenue. So to sum up the LLC filings, as of yesterday, we have a total of 237,710 active LLCs filed with our office. So, Mr. Chairman, before I move on to trusts, I'm happy to answer any questions you or the committee may have regarding LLCs.
And if you could just remind the committee the fee structure just briefly that generates that 7 million.
Absolutely, Mr. Chairman. An initial filing, whether it is an LLC, a profit corporation, or any of our other profit entities, none of the nonprofit, the initial filing fee is $100, which we did not raise that when we did our fee increase bill a year ago.
And then the ongoing fee is?
Mr. Chairman, the annual report fee, which is due every year, every entity must file an annual report with our office, and that is due on the first day of the month you formed. That fee is based on the assets located and employed in the state of Wyoming. The minimum fee is $60, and that covers assets from 0 to 300,000. If your assets are over 300,000, then there is the 0.0002 computation to determine your fee. And I can tell you, while we're on it, in fiscal year 2021, we had 193,000, almost 194,000 annual reports filed with our office, which generated $17.4 million for that fiscal year.
Thank you very much. Any other questions? Representative Jennings.
Thank you, Mr. Chairman. Deputy Wheeler, thanks for being here. I don't know if you heard my question earlier to the treasurer, but can you explain to us how that works, like how this information gets out, or the difference between discoverability and at what point does someone need to go to law enforcement and get a warrant?
Secretary.
Thank you, Mr. Chairman, Representative. So and I'll talk about LLCs since that is the topic today. When an LLC is filed with our office, they only have to list 3 pieces of information in their articles of organization. That is the name of the LLC, the registered agent and registered office, and who the organizer is. Now, to find out who is behind that entity, I'm going to have to take you back to the 2008 legislative session in which the legislature passed the Registered Agents and Offices Act, which went into effect July 1st of 2009. And the heart of what that act required was really touched on what is talked about today. And that is law enforcement would come to our office and they couldn't determine who was behind an entity because that information was not required statutorily to be kept. So the Registered Agent Act requires the registered agent to keep the names of what I'm going to call the key players for every entity that every domestic, every Wyoming entity that they represent. That information can only be provided to the Secretary of State's office or to law enforcement. So I hope that helped answer your question, Representative.
Follow up?
Yeah, just thank you, Mr. Chairman. So in this story that occurred in the allegedly there's this Russian oligarch, how would they have found that? How would they have discovered that?
Deputy Secretary?
Thank you, Mr. Chairman. So Representative, there have been 3 series of articles similar to the Pandora Papers. We started first with an article Reuters did back in 2011 regarding the little house on the prairie. Then we went to the Panama Papers and now the Pandora Papers. And what has happened, particularly in the Panama Papers and the Pandora Papers, information is leaked. And I think that was testified to earlier today. And that is how that information came out. I will tell you that in the Panama Papers and the Pandora, what we have found, there have been assertions made, but we have never been given any concrete evidence of charges being made or convictions against people.
Okay, any other questions? Gonna keep moving on. Okay, continue, please.
Thank you, Mr. Chairman. So now I want to talk about trust formations in the Secretary of State's office. So when an entity forms with the Secretary of State's office, and they have to first name their entity, the entity can have any word in their name that may or may not be indicative of the purpose for which that entity is being formed or will do business. So for an example, in looking at the entities that have the word trust in their name, I came across one that is a funeral home, and they happen to have Jones Funeral Home, Memorial, and Trust. So that is important because with regards to the word trust being in an entity name, the Secretary of State's office has had a long working relationship with the Division of Banking, which I was able to trace back through 1999. And this relationship is that whenever an entity forms with the Secretary of State's office and it has either a financial institution name like bank or banking or the word trust, our office sends a copy of the articles and a letter to the Division of Banking so that they can either approve the entity name as it has the word trust in it or object to it. If the Division of Banking objects to the use of the word trust in the name, they send us a letter outlining their objections. We send that letter back to the entity, and then they work with the Division of Banking to clear up any issues there may be. Once that entity resubmits their documents to us, we send it right back to the Division of Banking for final approval. Now, as of April 25th, we have 970 active entities that have the word trust in their name. So again, just because they have the word trust in their entity name does not necessarily indicate they are doing business as a trust. These 970 entities include limited liability companies, profit corporations, nonprofits, limited partnerships, registered limited liability partnerships. So, Mr. Chairman, that is what I have on trust and filing with the Secretary of State's office. I'm happy to answer any questions the committee may have.
Questions, Senator Schuler?
Thank you, Mr. Chairman. Yeah, just one question. And I think I probably know the answer to it, but I think it'd be great coming from you, Deputy Wheeler. Do you think we have enough regulatory safeguards within our banking industry and also with the attorneys in our state to make sure we keep the bad actors out, particularly since some of these trusts have multiple accounts within them?
Deputy.
Thank you, Mr. Chairman and Senator Schuler. I would have to defer that question to the Division of Banking.
we'll have them up shortly. And now Mr. Co-Chair Case has a question.
Hello, everybody. How are you?
Good, thank you.
It's good to see you again. Yeah, we've worked together a lot, and it's good to have former Senator Meyer, now Treasurer Meyer, some of the issues we worked on years ago. It's good to see you. I have a couple of questions. One's about the whole trust connection with the State Secretary of State's office. So it sounds like if you have the word trust in your name, and you have a business form, there's a double check that goes on. Is there any requirement that you have the word trust in your name, or, so is that just kind of coincidental? Everybody that either was smart enough or dumb enough to put the word trust in their name ends up possibly being double checked back and forth. And that would be the end of it, it sounds like. And that'd be the first question. Let's just stop there for a second. What do you, help me with that?
Go ahead, Deputy.
Thank you, Mr. Chairman.
There's no requirement. I'm sorry, Deputy Wheeler. There's certainly not a requirement that trusts register with Secretary of State's office and et cetera, et cetera. So we're kind of getting this coincidental overlap is what you're talking about.
Go ahead.
I'll shut up.
Thank you, Mr. Chairman, Mr. Co-Chairman. So as far as whether or not the entity has to have the word trust in their name, that, again, I'm sorry to do this, but I would have to defer that to the Division of Banking. I don't know the requirements there. And yes, it is a check, double check that we have obviously been doing for quite some time. Keep in mind, the only entities that are not required to file with the Secretary of State's office are sole proprietorships or general partnerships. All other entity types must file with our office.
But not a private trust, right, Mr. Chairman?
Mr. Chairman, Senator Case, if that private trust were to form as an LLC or a profit corporation, they would have to file with us.
I got you there.
Yeah.
So, Mr. Chairman, just to kind of imagine how this might work, if there might be an existing corporate form that might be purchased by a trust. And I guess down the road, you'd figure something out, but the ownership doesn't necessarily come into play, except for the registered agent would have to know a beneficial owner. So would that be right?
Go ahead, Deb.
Mr. Chairman, Co-Chairman Case, the overlying entity would have to have that information with the registered agent.
Gotcha. Then I only have one more question, Mr. Chairman, if I could. Ms. Wheeler, help me with the history here, and maybe even Treasurer Meyer. We served together on Corporations Committee for a long time, and I thought we eliminated all aspects of bearer shares, bearer bonds. I thought we got rid of those throughout our statutes. Is there any places where we, because that was mentioned in some of the testimony, that bearer instruments were part of the problem. I'm not aware that we have any of those. Do you guys know of any? And we'll ask that to banking too.
Director?
Thank you, Mr. Chairman. Mr. Co-Chairman, you are absolutely correct. I believe it was back in 2007 or 2008 that we specifically said in statute, you cannot have bearer shares. And the reason we did that is because it was being advertised that in Wyoming you could have bearer shares. Well, our statutes were silent as to bearer shares, so we took the silence away and we specifically said you cannot have bearer shares in Wyoming.
Thank you. Understanding.
Okay, thank you, Deputy. Deputy Secretary, any questions? Okay, proceed, I think. Anything else, or are you all finished up?
Mr. Chairman, that is all that I have today.
Okay, we're going to, if you can, you certainly would be grateful if you stick around if there's any more public comment or questions, those kind of things. And I understand if you can't. You got a busy office, so. But again, appreciate your time and all your information today and all your good work, your whole staff. Thank you.
Thank you, Mr. Chairman, and we will stick around to answer any questions someone may have.
Okay, great. Okay, next on the agenda is Wyoming Banking.
I never have good luck with bankers.
Good morning. It's good afternoon.
Good
now,
afternoon.
I
Good
almost
afternoon
said
now.
that, and
Thank
I
you.
just looked at my time. It is 12:10. It is good afternoon. Yeah, welcome and please introduce yourself.
Thank you. My name is Jeremiah Bishop. I am the Deputy Commissioner with the Division of Banking. I oversee the banks and trust company side. And just to point out, not a banker, we're a bank regulator. So hopefully that's a little better.
It's all good.
Thank you for allowing us to come speak today. I have a few items to go over, then obviously we'll stand for questions. First, there's a lot of discussion on fees. This is the Revenue Committee, so I will definitely discuss our fee structure, where that goes and what it's for. I also want to discuss how our office interacts with the unsupervised or unregulated private family trust companies in the state, and also how we generally oversee and how we interact with the supervised trust companies. That's both public companies and supervised private family companies. I'll probably skip over that one a little bit more generally, but if you have any specific questions, be happy to answer those as we go. First off, we'll go over the fee structure. First off, the Division of Banking is an other fund agency. So the fees paid to our agency are for the cost of supervision. We are supposed to ensure that the fees collected from our institutions cover the cost of supervision of those companies. And that's why we are an other fund agency right now. I don't believe we have any fees that go into the general fund. I'll just kind of go over roughly some of the fees charged to trust companies. First off is an annual supervisory fee. This is set based off assets of the company. I think it's $7,500 if you're up to 3 million in assets, and anything over 3 million assets, I think it's 12,500. And again, that is assets of the company, not assets under management. That's an important distinction. And then those fees, part of that goes to our cost of supervision, and then part of that also goes to, we have a resolution fund that we set up, and that is to be used if we ever have to take receivership of a trust company. That's a very expensive process, and so we kind of have a fund set aside to cover that cost. Secondly is an actual examination fee. Once we perform an examination of a trust company that's supervised, we assess an hourly fee plus travel costs, and that is again to cover the cost of that supervision. Third, Liz was talking a little bit, if a trust company offers custody of digital assets, we do have a separate fee that we charge them based off of the value of those custodied assets. I can go, if you want to know exactly what that is, we can go into that. And then that one, it's if it's greater than the normal fees, then we collect that. If it's less than, then we do tweak that a little bit. Again, these fees are also set in through the rules process. They're not in the actual statute, but the commissioner rules goes through that process to set these fees. A final.
I think we have a question here, Representative Henderson.
Thank you, Mr. Chairman. Regarding your fees on digital assets, do you differentiate between foreign assets versus domestic?
Great, thank you,
Go
Mr.
ahead.
Chairman. Thank you, Representative Henderson. No, we do not. Right now, our fee structure, it is just total assets regardless of where they are.
Okay, thank you.
One other fee that we do collect, this is as it relates to the unsupervised, unchartered private family companies. Somebody mentioned that they can pay us a $250 fee upon formation. That is not required. That is for a letter of assurance. It is not a requirement that these companies get this. They do have to file a waiver with us. I can go over that here in a little bit. And a part of that waiver, they can check a box saying, we want a letter of assurance from the Division of Banking stating that we are complying with what we're supposed to, and we give them that letter. I just wanted to point out that $250 is not a requirement at this time. That's all I have on the fee structure. I take any questions on that specific topic.
Hey, Senator Pappas has a question.
So thank you, Mr. Chairman. So based on those fee numbers and being in rules and regulations, I'm assuming if they weren't adequate, you would be seeking to change the rules and regulations, and that probably this committee would probably not need to go there, but I did, again, as I mentioned earlier, that the Wyoming Trust Association suggested increasing them, and just want your thoughts on that.
Thank you, Mr. Chairman. Thank you, Senator Pappas. Yes, that is a process. If we evaluate during kind of our budget process, the cost of supervision exceeds the fees that we are collecting, then yes, we would go through that rules process to amend those fees so that it does cover the cost of supervision. And we would definitely get the Trust Association involved, at least to get their input on what our proposed fee structure is. Obviously, there's a comment period with that rules process, but that is something that we would evaluate ongoing.
Okay. Continue.
Mr. Chairman.
Oh, I'm sorry, Mr. Co-Chair has a question.
Yeah, I'm sorry. I thought you were talking to me. It's really good to hear all this. Sort of what I hear is that people are willing to accept more fees. I kind of hear that the banking division is, they're okay with the fees because they cover the cost now. You've got them set where they are. So would there be more supervision if we allowed for more fees? Or that's kind of the first question. And then the second question, I'll just pile on. All these fees are cost-based, except for the one that I understood was the custodial fee for the digital assets. That sounds like it's based on the value somehow of the digital assets. So that's the only one that's based on the value. I mean, there's obviously significant value to the assets that are managed, and the fees don't account for that. I'm really not suggesting that we should, but why the difference between the way we approach digital assets by the way we approach monetary assets?
Mr. Bishop?
Yes. Thank you, Mr. Chairman. Thank you, Senator Case, for that question with the digital assets. This is a new industry in that area, and the cost of basically regulating that industry is pretty significant. And so we would be spending much more time supervising entities in that industry. And so having it tied to that kind of helps cover that. Obviously, it's a very new product and that increased supervision. And again, since this is new, if we find that those need to be adjusted up or down, depending on the cost, we can do that. And I do, forgive me, I can't quite remember your first question.
Thank you, Mr. Chairman. It's more like what I hear from the Division of Banking at the moment is that, you know, our fee structure covers our costs. We have the authority to implement them and cover our costs. It's not in statute or anything like that. We don't give any money back to the general fund. That's different than the Secretary of State's office. But I also hear from the practitioners that they could tolerate some increased fees. So would there be more supervision if there were higher fees? Would that be better? Just help me. I'm just floundering around here.
And I think add to that too, you know, what's your current balance? What was it at the end of the last fiscal year? And thank you.
Yeah, thank you, Mr. Chairman. Thank you, Mr. Case. I would flip that around, and that we don't really increase our supervision based off the funds we have. We determine what the level of supervision needed, and we adjust the fees to cover the supervision that's needed. If that makes sense. And as far as Mr. Chairman, your question, I'd have to look at our specific balance on what our actual fund balance is right now. Off the top of my head, I didn't write that down prior to coming here, but we could get that information for you if you'd like.
Ballpark?
I think it is several million at the moment. Ballpark, I'm guessing about 3 to 4 million at the time right now. And again, this is also just covering bank and trust company fees. We have a multitude of other types of entities that we do regulate.
That 3 to 4 million number includes the digital asset fees.
Currently, thank you, Mr. Chairman. Currently, we do not have any companies that are being charged that fee at the moment. So,
okay, thank you.
Moving on, I'd like to make talk about our oversight of supervised trust companies. I think some of the prior people did discuss the types of entities that we supervise. I'll just do that very briefly since it was talked about already. But first one is public trust companies. These are non-depository trust companies that offer services to the public. We are involved with them, one, in the charter process. They make an application to receive a charter to operate a company. Our office, we take that application, we perform the investigation, and then we participate in a public meeting with the state banking board. And the banking board is the entity that takes in that application and either approves or disapproves that charter. We also have supervised private family companies. These are these companies that are choosing to be regulated. So they also come to our office with an application for a charter. We do a very similar investigation process for these companies. The one difference is these companies do not go before the state banking board to approve the charter. That falls on the commissioner to approve or disapprove that charter application. Once they become chartered, then we move into the supervision process. Public trust companies and the private companies, all supervised companies, undergo regular examinations, safety and soundness examinations. Very, very quickly, this is kind of an overview of what we look at. It's risk-based. We have to kind of tailor the supervision based off of the activities of the company. What's the risk profile of the company? What activities are they getting into? That's where if they are doing digital asset custody or any kind of higher risk new entities, it's going to take a lot more time to perform that examination process. And we need much different resources for that type of activity. We very quickly, we look at the safety and soundness, the condition of the company, the overall management, internal control procedures, the operations, the earnings, compliance with Title 13, overall asset management. And then a part of that examination, we do do a sample review of accounts. We don't look at all accounts of a trust company at every examination. I'd like to point out that's the difference between being an examiner and an auditor. We don't look at every transaction. It's a kind of a risk-based approach, and we do a sample on that. I would also say that we do a review of BSA requirements, so Bank Secrecy Act, AML requirements. These are I think this has been discussed a little bit up till now. These are federal requirements that all financial institutions must follow, including trust companies. These are, know your customer, customer identification. It's called a customer due diligence process. You must assess the risk of a customer and determine if you need more enhanced diligence of that customer. We do a review for that as well. Going to the account review, again, we don't look at every single one. It is more risk focused. We try to review different types of accounts. Obviously, as I just said before, there's an enormous different types of accounts out there. So we try to pick different ones. We look at different asset types, usually unique assets that might be harder to manage, pose a higher risk to the company. We might pick some of the higher dollar volume accounts to review. And as we're reviewing these accounts, we're really going through the trust company's process of onboarding these customers. Are they in compliance with all the BSA requirements? Are they doing OFAC checks for sanctions lists? Are they doing kind of just the basic, who are these customers? Where's the wealth coming from? And what activity can be expected? I did OFAC since, just again, I would point out with the trust industry, that process is very important. A bank does a similar process. However, a bank, they can quickly cut ties with the customer if they don't want to be involved. A trust company, that is much harder. These are usually very long-term relationships. And at times, even if they want to get out of that relationship, can be a very long and time-consuming and expensive process, possibly even a court system. It depends on the situation. And so trust companies do have to do a very much in-depth review of, do we want to be in business with this person or entity? And when I say that, it's the grantor setting up the trust, the purpose of the trust, any beneficiaries, any beneficial owners, if it's a LLC or company, things like that. We review compliance with a governing document. That's probably the biggest section of that is disbursements, things like that. Are they doing what they're supposed to with that legal document?
Representative Henderson has a question.
This is an easy question to ask. I'm not sure it's easy to answer. Thank you, Mr. Chairman. Very, very important to understand, the source of where these funds or this value is originating. How do you satisfy yourself in your rules and regulations, particularly in regard to the new emerging digital assets?
Thank you, Mr. Chairman, Representative Henderson. Yes, the companies can go about that many different ways. A lot of it is just discussion with the customer. A lot of times with trust companies, they only work on referrals. So who is referring this customer? How long has that relationship been in place? They might do other searches. Obviously, they can do OFAC searches to determine if that person's on a sanction list. They can do basic web-based searches to see if there's any public information on that person, on where their funds may have come from. If it was a referral, they can have that discussion with the person who referred them to get information on that. It's not an exact science, I agree, and it can be difficult. And so that's why they do need to have policies and procedures for what steps will they take to determine that. Not only at an account acceptance, but then again, they also need ongoing due diligence of their customer. Hopefully that answers your question.
Okay, very good. Okay, I think continue.
Thank you. A few questions that did come up, I think were spoken about earlier, and that's kind of what tools are available to financial institutions, including trust companies, for screening customers on any kind of list. Part of that is OFAC compliance. Any new customer must be run past an OFAC check. Are they on a sanctions list? And especially with the current events going on right now, companies should also be probably scrubbing current customers to see if they have shown up since the account opening, to see if they're now on an OFAC list. If they are, there are very certain requirements they have to do and steps they have to take regarding that customer, and they correspond with federal agencies on that. Another one is called a 314A list. This is something that FinCEN uses. I think it goes out every 2 weeks. A law enforcement agency, if they want information on a person transaction, they can provide that information to FinCEN. And FinCEN pushes that out every 2 weeks to every financial institution. And they have to basically scrub their client portfolio to see if they have any positive hits on that list, and then report that to FinCEN. I think that came up before, as I did want to go over that process. Moving on a little bit to the unsupervised, these are the private family companies.
We have a question, Representative Yan.
Thank you, Mr. Chairman. So the part where there's some financial reporting, mostly because it goes to the US banking system. So one of the things that was pointed out on the Makarov part was he had an unregulated trust that where the asset was a British Virgin Islands company. Is there any reporting of that kind of asset anywhere in the US?
Thank you. I can't speak exactly for what all they would need to require. I can speak to what we would require. Not very much, since that is an unregulated company. We do not supervise those unregulated companies, and so we don't have very much information on what may have gone on with that. However, I will say that anybody who opens up a basic banking account or any other account with a financial institution has to go through that same VSA requirements.
Thank you, Mr. Chairman. So that requirement would only be necessary if they had assets in the US banking system.
Thank you, Mr. Chairman. Representative Yen. Generally, yes. However, I may not be the best person to describe the exact steps that person may have gone to without having the details in front of me. I can only speak of if that was in our financial institution, what would be required.
Representative Senator Case.
Thank you very much, Mr. Chairman. So I'm trying to understand, it sounds like there's a lot of reporting if it's a regulated trust company, public trust company, a lot of reporting. If a private trust company registers with you, I'm not sure what reporting is required. It sounds like you pay $250, you can get a letter, but it would seem to me that we know a lot about these regulated entities. It's the unregulated entities, totally private trust, for example. We could envision, you pick your bad actor, comes in, legally in Wyoming establishes a trust and has a private regulation of that trust. The assets may not be even monetary assets. They might own real property. They might have somehow acquired real property, either brought it in or somehow purchased and resold. But we're talking about stuff where there's not normal reporting requirements in the banking system. It seems like that's the door that's open, and maybe that's the piece that is where the so-called bad actors are. You think we're onto something in that, and what do you do about that? And that's what I'm trying to figure out.
Mr. Bishop.
Thank you, Mr. Chairman and Senator Case. Yes, I agree. And that's actually my next portion. If you would like, I can go through with what we do, how we are involved in those unregulated companies. That might answer a little bit of your questions, and then give you a little bit more information, and then I can follow up with any questions if that
Sounds
works.
great.
So these private family companies, they can act as trustee, usually for one family. I think that's been discussed already. Right now, we do not supervise those companies. We do not perform safety and soundness examinations of those companies. If these companies form, they do have to file a waiver with our office that acknowledge that they're not supervised and that they will not do business with the public. Right now, I think we have 395 of those waivers. This goes back to 2015. That's not indicative of the number of companies out there, because some of these could never have actually become operational. Some of them could have ceased operations, etc. So we receive those waivers and we keep those on file. Secondly, this goes back to what was discussed with the Secretary of State. If a company has the word trust in the name, we do work very well with the Secretary of State's office. They constantly send over all the information that Ms. Wheeler discussed earlier. What we review is if it has the word trust, we have certain statutory naming requirements that if you have the word trust and you're an unregulated company, that it has to basically state that this is a private family trust. It's very specific. We also have a few other things on what needs to be included in their articles. And so that's what we review. And then we add that to a list, and then we make sure we get the waiver later on. Usually that comes in after the company's formed, but we send that information back to the Secretary of State. And usually that company, if we deny it, comes back to our office, and we work with them to make sure they meet the naming requirement. Third is if our office believes that a private family trust company proposes to transact or has transacted business with the public, then we may conduct an inspection of that company and take any appropriate action as needed once we've done that investigation. Besides these three factors, the provisions applicable to the supervised trust companies don't really apply as much to these private family companies directly. But again, I will say that it is indirectly through any accounts opened at a supervised financial institution, including a bank. So that's very limited role that we do have with these unregulated private family companies. And I do understand that is kind of the whole purpose of this discussion. Kind of getting back to your question, Mr. Senator Case, being the division of banking, it's hard for us to really speak specifically on what could be done in this area. We can discuss how we could administer any policy changes. We're not in a position to really discuss on whether or not those policy decisions might be good or bad simply because we're a government agency, which you're very familiar with. And I think the trust industry might be able to speak a little bit more on that. I think they have. That is all I have. I'd open it up to any questions at all.
Okay, very good. I'm going to start here, working around. Any questions? I don't see any, and I think we're going to go to public comment, and there might be some opportunity where, question or it gets into more conversation. Really appreciate your preparation and your information today.
Great. Hey, thank you very much. I very much appreciate it.
Thank you. Okay, committee members, we're at this point I mean, you could take a break for lunch, or we could keep on working. And
I think we should finish this topic.
I think we keep on working. And then since we all have to leave, almost all of us have to leave beautiful Lander today. Okay, so we're gonna keep on working, folks. So if you have that growling in your stomach, well, it'll be all right. Okay, next on this topic, public comment. Are there any folks here who would like to comment on anything you've heard or those kind of things? Just come on up and introduce yourself, identify who you represent, and we welcome all public comment. And we'll do everyone here in the room, and then we'll move to online and back and forth as we need. So good afternoon.
Good afternoon, Chairman and committee members. Thank you for your time and for your service to the great state of Wyoming. My name is Jen Lowe. I am the Executive Director of the Equality State Policy Center. We are a nonprofit that advocates for fair elections, transparent government, and thriving communities. As you may or may not know, ESPC is the organization that brought this topic forward as a proposed interim study topic. And you can go ahead and call me naive because I severely underestimated the amount of attention that this issue would draw. My concern is the reputation of the state of Wyoming. And regardless of your opinion of the Washington Post and the Pandora paper articles, there is a negative light that has been shown on our state and some of the practices that we have here. This is just one leak, the Pandora papers. Who knows how much is really out there? According to Mr. Gruel, 2%, up to 2% of the national GDP could be ill-begotten funds. This country has a long history of discovering important information through leaks and whistleblowers. So although you might be tempted to doubt what is in the Pandora papers, I think it's worth considering that it also may possibly be very true. LLC and trust is clearly a very complicated issue, just based on this limited conversation that we've had today. It's extraordinarily complex. And I commend you all for taking this very seriously, and for all those that were here today to testify, to kind of give us an idea of what this all entails. What is obvious to me is that trusts are a very important vehicle for protection of wealth and property. And it is important that we continue to provide trusts through Wyoming. However, it does strike me as quite interesting that current trust assets are estimated in Wyoming to be $35 billion, which is roughly the same as the state's entire GDP. There's a lot of money that really isn't benefiting all of the folks that live here in Wyoming. We've heard a lot about the top 5 best states to house a trust. Delaware, South Dakota, Nevada, obviously are the premier states, but Wyoming and Alaska are not too far behind. And if you spend any time on any of the trust websites that I visited, almost all of them are marketing exclusively, well, not exclusively, but all of them are marketing to out-of-state and international clients. That's clearly a market the trusts here in Wyoming are interested in growing. Not that there's anything wrong with that, just worth noting. I'd also like to point out that the Corporate Transparency Act that we've talked about earlier has not been implemented. And according to some optimistic guesses, the soonest that the CTA will be up and running is January of 2024. There's a lot of time between now and then. And I'm also quite certain that people much smarter than me are already coming up with ways to circumvent the CTA. Again, my concern for bringing this issue to the committee was the reputation of this state and for the hardworking, honest, and trusting people that call Wyoming home. I'd like to thank you all for taking this topic up and for taking it seriously. I look forward to working with you on this issue during the interim and happy to answer any questions you might have.
Okay, thank you. Any questions, Ms. Lowell? Okay, well, thank you.
Thank you.
Appreciate your testimony, your involvement in this. Appreciate it. Okay, any other folks here in the room would like to just come on up, and you can actually, we have 3 chairs there. You can kind of stage, get up to the plate on deck, and it'd be great. And go ahead and just re-identify yourself for folks who might be watching online.
Scott Weaver, on behalf of the Wyoming Trust Association.
I am Chris Reimer, partner at a law firm here in Wyoming. And just noticing that Scott and I look a lot alike on the screen here. We're not related.
Chris and I discussed after hearing Mr. Garol's testimony that we thought it would be helpful to come back during this public comment period to address some of the questions that he raised, both about the nature of the reporting on our state's trust industry, and then also to discuss some of the factors and suspicions that he raised about what may or may not be able to occur under the auspices of the Wyoming trust industry. So I think the most important thing to emphasize is that that Washington Post article and all subsequent reporting on the Pandora Papers have clearly identified, even in the article itself, that they were not able to identify any unlawful activity or any criminal funds as a result of these leaks. And so while we think the financial integrity of our national and of our state financial system is absolutely of paramount importance, we don't believe that Wyoming trusts have been alleged or ultimately concluded to have actually violated any applicable rules or regulations. As a result of that article, I expect that many of these structures have been subjected to revisited and increased scrutiny. And to my knowledge, there have not been any public investigations, nor indictments, nor convictions, nor civil or other regulatory inquiries as a result of that article. Moreover, I understand that some of the people mentioned in that article, reasonable minds can differ about whether or not you think those are the types of people who Wyoming businesses ought to be doing business with. Nevertheless, we are legally allowed to do so. And as I understand it, none of those people mentioned appear on OFAC or other sanctions lists. So they are lawful customers engaged in lawful business. I think Representative Sweeney asked a very important question of Mr. Garol. Do you have any specific allegations or any specific circumstances that you find objectionable? Or is this more a case that, well, something bad could happen someday? And my understanding of his response was that he was not able to identify any actual wrongdoing. The second point I'd like to make on this is that he explained some structures that might look complex or confusing. So I'd like to speak briefly to the federal Know Your Customer regulations that are incumbent on each financial institution to follow. Obviously, we need to know names and addresses and countries of residence and social security numbers or tax ID numbers, but we also have to go through additional diligence. That includes things like identifying source of funds. Sometimes it's obvious, other times we have to ask and inquire. But if we can't satisfy ourselves as to the propriety of the source of funds, we're not allowed to do business with that person under existing federal rules. Beyond that, we also have to understand the planning purpose, not just of the trust that we're asked to be the trustee of, but also of the other entities within the structure. I.e., if we get a trust that owns a British Virgin Islands entity that owns an LLC somewhere else, we have to understand the why that underscores that structuring decision. So typically, we would expect conversations, written legal memorandums, structure charts, other documents that evidence the who, what, when, where, and why behind the way that these structures are designed. Sometimes they are highly complex, just as the family's finances are highly complex. And when you introduce cross-border planning into this ecosystem, the complexity gets much greater. The reason for that is because I think we would all agree the United States tax code is not simple. And when you start reconciling the United States tax system against the tax laws of a foreign country, and then you begin to figure out, okay, structure A works in the United States, but it doesn't work in the foreign country. Structure B works in the foreign country, but doesn't work for the family in the United States. Oftentimes we get complex structures and systems as a result to make sure that both countries' tax codes are fully complied with, and we get the outcome that is good for ultimately for the family that we're seeking to serve. I would also add that in these types of cross-border structures, which seem to be the primary focus of inquiry today. There are a variety of tax reporting obligations that fall, for example, to US trusts that own foreign companies. They have to file an annual form with the IRS. If there are US trusts that are signatories on foreign financial accounts, there's reporting that has to go to the IRS. And then the United States government, in addition to FATCA that Mr. Reimer previously mentioned, also has intergovernmental agreements with a number of foreign countries that go to this sharing, sometimes bilateral, sometimes otherwise, of financial information on their country's residents who are doing planning in the United States. And so for any of these structures, in order to do an ounce of financial business in the United States, whether that's open a bank or a brokerage account, or even engage in a real estate transaction, that structure has to provide the appropriate tax form. It's either IRS form W-8 or W-9, depending on whether you're a US person or a non-US person, that discloses the name of the entity, its address, its tax identification number, its country of residence, if not the United States, and then its treatment under some of the laws we've just made reference to, and including its tax treatment. Because if I'm a title company in Wyoming, someone comes to me and says, hey, I want to engage in a real estate transaction, the buying or selling of property, then I know that it's incumbent on me to make sure that I comply with my obligations to report applicable capital gains or losses or other income tax or taxable events, because that's part of my job as that title and escrow company. So a lot more information is provided than I think perhaps has been alluded to. And I think this also goes to illustrate both the complexity of the financial reporting structures that have been adopted, but also their breadth and applicability. So perhaps I'll pause there for a moment if there are questions or comments.
Representative Henderson.
Thank you, Mr. Chairman. This is good information. As I hear it, I'm thinking, okay, so we have no one that I know of that can live 1,000 years. So what happens when the trustee transition or must transition? Could you help me understand it? Or registered agent? What happens with that? Thank you. Go ahead.
Certainly. Thank you, Mr. Chairman and Representative Henderson. I'm going to hope that Chris and I might be able to tag team this one. And perhaps I'll start and I'll trust you to interrupt me. Sure. Good. So trustee succession, i.e. when you have a human serving as your trustee, is governed first by the terms of the trust agreement. So often a trust will say, Mr. Reimer will serve as my initial trustee. And in the event he is unable or unwilling to serve, Mrs. Andrikopoulos will serve as his successor. And then in the event none of the people who are listed as successors are able to serve, then a majority of the adult beneficiaries of the trust may choose a successor trustee. And then if none, a court in Wyoming or whatever jurisdiction the trust lives has the power to appoint a successor trustee. And then the Wyoming Uniform Trust Code contains default rules on how that trustee appointment process is to be conducted in the event of a vacancy. And so one reason that our clients like using corporate entities is because that trustee succession process is administratively tedious. You have to contact every asset custodian and let them know that the identity, therefore the legal ownership of the trust asset has changed. You have to provide updated information so they can satisfy their know your customer and know your client rules. And then you have to form these new relationships. So many times client families that are looking at doing multi-generational wealth transfer planning. So not just parents to children, but parents to children and grandchildren and so forth, which can be very important in a state like Wyoming, where we have large agricultural properties that are highly valued in today's market. They like having an entity because entities don't die in the same way that Uncle Bob might. So they like using an entity because it means that they have that built-in succession planning, not only in terms of going through the trustee succession process, but they also have built-in additional services. There's redundancy among businesses where they have multiple employees. And there is that institutional knowledge because, as a previous speaker has mentioned, these trusts are multi-generational. And it's absolutely incumbent that the trustee know the family that they serve because ultimately they have to make decisions that they believe are in the family's best interest. And so if you have that institutional memory preserved over time, then that, we think at least, that leads to better outcomes for families.
I don't have anything to add to that answer. Thank you.
Thank you, Mr. Chairman, Mr. Weaver, Mr. Reimer. In the situation that was posited earlier, the Makarov situation, it's an unregulated trust company. And you noted that there are certain things that they have to do anyways as part of their duties as a trustee. But as an unregulated company, no one knows about it. How do we know that they're actually complying with those obligations?
So, Mr. Reimer.
Yes, thank you, Mr. Chairman. Representative Yin, I have noticed that you've been coming back to this question. And while I was not speaking, I went and looked up, and I wanted to tell you, so I'm glad you asked, that in that particular situation where, let's say, we have a unregulated entity, which is a trustee of a trust in the US. I'll come back to that in a second, but it somehow opens an account outside of the US, like the BVI. You asked specifically, is that a mechanism by which that person would be hiding funds from their own home country? The BVI is a member to the Common Reporting Standard Agreement, which I looked up in the interim. So the answer to your question is no. If that person who set up that convoluted structure using a Wyoming unregulated PTC to go open a bank account in the BVI is from a country which is a member to the CRS information sharing agreement, all of that information is automatically shared among those governments. With the US, it's a little different. We're not a member of CRS. We have our own system called FATCA. But what you described and we're questioning, if somebody were to go to the effort to do that, their information would be in the entire regime of CRS reporting nations that share information about that. I would like to conclude with a point about Wyoming unregulated private trust companies, and they exist in other states as well. Even if it's true, I disagree with Mr. Jarul, who said that Wyoming's laws allow someone to completely avoid the banking system and the federal laws required for banks and trust companies to know who their client is. I would like to know what bank that is, because if you take an unregulated private trust company, it has an owner, it has people, that it has a source of funds. You have to go to a bank to open an account and disclose that information. And if you don't, the US bank will not open an account for you. It's that easy. But even if it were true, that the secrecy or the inability, or it was not reported automatically to some government agency when an unregulated private trust company is formed, moving forward with the Federal Corporate Transparency Act, by definition, in Wyoming and any other state where there is a unregulated private trust company, which is a corporation or an LLC, will have to make a filing to the federal government. And even if it's other country who's looking to see, and they look at a BVI structure and they're like, well, who's behind ABC LLC from Wyoming? All they're going to have to do is use their liaison with the US federal government, say, who's behind ABC Wyoming LLC? And the federal government will have that information. They will have to have it by virtue of the new Federal Corporate Transparency Act. And astutely, Representative Pappas asked me, well, why don't we just have 6 trusts, all of which have less than 25%? I think the federal government made the 25% cap in getting that information just because this is a bear of a project to get information on every single company, limited liability company and corporation ever to be formed in the United States. And if as time passes, they need more information, say a 5% owner, we should let the federal government do that, and they will have that information. And people who are in law enforcement outside of the US, inside the US, in Wyoming, will be able to access that database at the federal level. That issue, which is very easy to put in a law in a newspaper about the secrecy of Wyoming, and we're helping nefarious people do that. that issue is going away. Like the federal government has put the nail in that coffin with the Federal Corporate Transparency Act. All 50 states are on the same level. All entities are going to have to file. And that's what I would leave you with unless there are more questions.
Might I add something to that response?
Go ahead.
I think the notion of an quote unquote unregulated PTC is something of a misnomer. It is an unchartered PTC insofar as the Division of Banking has not authorized its charter issuance or operation. I would refer to those as self-regulated private trust companies because they have boards of directors, they have officers, they have assets, and all of those corporate officers and directors have duties that arise under state and federal law to appropriately and lawfully administer the private trust company. And so it's incumbent on those directors and officers to satisfy themselves that the trust company operations are above board. And if they're not, then just like any other corporate officer or director, they are subject to civil and criminal liability for running an operation that is not in compliance with all of those applicable laws. So while it's true that there is not a government body who is engaged in periodic examination, it's not as if these entities somehow escape scrutiny and escape the law. And I would further reinforce what Mr. Reimer noted about opening bank accounts. I disagree with the notion that a Wyoming private trust company of any kind could operate with no financial footprint in the United States. And the reason is because to be a private trust company in the United States, you need to have some combination of legal, tax, administrative, corporate offices, and other support that are going to have to be paid in US dollars, probably from a US account. And if it would come from a foreign account, then those service providers would be disclosing that as part of their tax reporting process. So while I think it's an easy picture to paint, pragmatically, I think it'd be very difficult, if not downright impossible to implement.
Any other questions? Representative Sweeney.
Thank you, Mr. Chairman. So it seemed to me in some of the testimony, we were basically being painted with this broad brush and basically we're a bunch of hicks out here and don't know what we're doing, which I totally fundamentally disagree with. So in your particular case, in your opinion, do you think there's something this committee should take on to help? And I've seen others in previous years, probably 6 years ago, come to the state about transparency and really cost a lot of people, a lot of organizations, a lot of money to provide transparency for a lot of organizations that were already doing it and cost a lot of people a lot of money. And so is there something that this body could take to the greater body of the legislature that would be helpful to the industry? And I'd appreciate that. Thank you.
Okay, yeah, please.
Mr. Chairman, thank you. Representative Sweeney. From where I sit in practice, there's no law regarding information of entities or private trust companies or trusts that needs to be implemented in Wyoming for its sake. If the Secretary of State came to you and said, this is how we regulate registered agents and this is the information they have, and they wanted to tweak that or increase that, I'd be all for it. If the Division of Banking came to you and said, this is how we deal with regulated trust companies and unregulated, and we need to tweak that, I would be all for it. But from where I sit, there's nothing that this committee needs to take to the body to solve any sort of problem. The problem that is in the national news media is whether the federal banking system has the appropriate controls to stop or slow down people who want to use the US banking system for bad purposes. And the next step in doing that has already been taken by Congress through the Corporate Transparency Act. I would let that roll out. Maybe it needs some tweaking, but there's nothing that this body needs to do to solve the federal banking system problem.
Mr. Chairman, might I supplement? I think Ms. Lowe, who spoke previously, raised the absolute critical point that our state's reputation is important. It's also our stock and trade. If Wyoming has a reputation for doing business with unsavory actors, Wyoming has a reputation for lax oversight of its trust providers, then that is bad for our industry. The Wyoming Trust Association was formed specifically to maintain and enhance Wyoming's reputation as a leader in this industry. But a leader in this industry is not a race to the bottom. A leader in this industry is providing safe, sound, sophisticated trust and trustee services to people who will benefit from using Wyoming trusts. And so that's why, as the Trust Association, we've supported the Division of Banking's request for taking another look at how their examination fees are charged. That's why we've supported an increase in those, should the division determine that it's appropriate to do so. We think right-sized regulation benefits everyone in Wyoming. And the other point I would make is that the customers that we serve are engaged in an exercise in choice, not only between jurisdiction, but between service providers in the jurisdiction. And if Wyoming has a reputation for anything other than excellence, then our industry as a whole suffers. So I think that's absolutely essential. To the specific request, the Wyoming Trust Association has previously and would be glad to continue our efforts to collaborate with lawmakers, the various executive agencies, to make sure that any of their recommendations are reviewed, and the industry, as I've said, broadly supports making changes that we think are in furtherance of maintaining Wyoming's reputation.
Okay, Mr. Co-Chair.
I think I agree completely with that analysis. I still keep circling around to what does Wyoming get out of this? I mean, we've done a good job of providing a legal structure for this business activity. It's a good thing. We also are a state that's in transition. The carbon-based economy that we have built this state on for at least two, possibly the last 2 decades in a big way, but really since statehood, it's changing. It's changing out from underneath us. Intellectual property, that's a good place to go. Service economy, good place to go. Sounds really good for getting us in transition and to a new place. But we don't tax any of it. And you're saying, well, if you tax the assets in trust or have an income tax, and I kind of disagree with my co-chairman that I think an income tax, at least a gross receipts tax, is a possibility. We definitely considered a corporate one, and we moved it quite a ways along, past one house, got to the other house. We have talked about a gross receipts tax. So those are all things on the table. But I also point out that our tax structure isn't very conducive to this. For example, it sounds like where Wyoming's real advantage is the laws that make it a good place and the practitioners that are here to do this service. We don't tax this service. We don't tax attorneys' fees. We don't tax CPA fees. We don't have a custodial fee, and maybe we shouldn't, but those are things I'm still very possibly enthused about. South Dakota taxes accounting fees and lawyers' fees. Yet they still get the trust business. So I don't know. We've got to move this economy and this tax structure somewhere else. We got to follow where the business is. This business is bigger than the mining industry, oil and gas industry. It's bigger in a way of measuring its static assets. It's not really bigger in terms of the income, I would suggest. But as Wyoming changes, we got to follow the money a little bit somehow. So I'm just throwing that out there.
Thank you. I think you're kind of echoing the former senator, former colleague, good treasurer. You don't have to offer below costs. And I think, the Trust Association has offered that up as well. And so we want to keep working on this deal. And as we kind of continue to modernize. We're not the only state having these issues. I mean, we're all talking about it as we transition, keep modernizing our system.
Were we going to allow rebuttal from the other side?
Well, and so we're still on public comment.
yeah.
So if you gentlemen are finished, if that's, we really appreciate it. And I'd like to open up to others in the room. And thank you so much. It's been really an educational process. Anyone else here would like to, any public comment on anything on this topic? And then I'll move, see if anybody online would like to comment. Public comment. Okay, I don't see anybody here. Is there anybody online that has their hand up? Go ahead. Mr. Rules.
If possible.
Is it Mr.
Chairman?
Rule?
Yes.
There you are. Okay.
Thank you, Chairman and Senators. I just want to, I do have timing constraints and will unfortunately have to drop in just a moment, but I wanted to thank you again for having us and to offer the FACT Coalition to continue this conversation. I think that there were some really good questions raised in the last response from the two gentlemen from Wyoming. I want to stress that the concern that the FACT Coalition raises is one of the sophistication of Wyoming trust law, not the opposite of that. And that I do agree that, as you mentioned, Mr. Chairman, this is not an issue that's isolated only to Wyoming. However, it is an issue that has exposed itself in Wyoming, and one that Wyoming can be a leader in addressing some of the state concerns that I hear being raised today. So with that, I'll just make myself available. We are more than happy to talk about the different ways that folks might invest outside the banking system, whether through real estate or otherwise. But don't want to get too technical with the remaining time that I do have.
Any questions? Mr. Guru? Okay, well, thank you so much. Appreciate all your work and your help. I think
thank you.
Our Treasurer Meyer maybe has a question here. So he's gonna, Treasurer Meyer.
Well, just a little comment. I think that the banking division, I think clarified and made it really clear about, the know your customer rule and those things there. And yeah, I think the only possible hole that you might have is if you do have somebody that doesn't have a banking account and just uses this primarily for total offshore purposes, that they wouldn't go through our process and get vetted in some way. And so I think that's the only small hole that I see. The other thing that I see is that the unregulated trust companies don't have the same vetting that a regulated company would have. And I'm not sure whether the banking division has the optionality of doing basically that know your own customer checks that they do for a regulated company. But that might be something that it sounds like the banking division is doing it for probably less than maybe the unregulated trust companies could actually do it themselves. So whether that optionality exists, I don't know whether it does or doesn't, but that's something that might be interesting to make available to the unregulated companies. And then like I say, the only other thing that doesn't go into that know your customer is if you had somebody that operated entirely out of the realm of the U.S. banking industry. So that's the ones that you might want to have the Secretary of State go back in and essentially check them across all of these different checklists of known bad actors, and maybe do that once a year. I think that'd be a very, very small number that don't have a U.S. bank account, and that'd be a fairly low bar for anyone coming in and asking to, be part of our formation LLCs to actually cross. It's just have a U.S. bank account. So the bankers would have to go through and do the know your customer.
Yeah. Turn my mic on. Thank you, Mr. Treasurer. I think Representative Sweeney has a question.
Just a question or quick thought. I appreciate that. Do you believe, so going home today, I'm thinking about going through Jeffrey City. In my mind, how are we going to regulate if I stopped in Jeffrey City and robbed the bank, which one doesn't exist? But
I just went through Jeffrey City. Good luck.
You missed it too. So, and robbed the bank. How is Wyoming gonna regulate that? And I think your idea of simply checking the LLCs and for nefarious purposes is a great idea. But I think we're getting lumped in to a greater effort, nationally in conversation because of one possible bad actor that. So I just I appreciate your thoughts on that.
I guess you see
Go ahead, through the chair.
Excuse me, Mr.
Yeah,
Chairman.
no, you remember the old.
Yeah, you see the federal government trying to move forward with this bill. It sounds like it's on the fast track and would probably go through. I hate to see that growth of that bureaucracy, because once they get more and more information, we're just going to get more and more intrusion into our daily lives. Because they're going to use it to essentially say we're going to go after the bad actors. But believe me, they're going to have everybody's information on everybody at now at 25%, and it'll go down to anybody that's got a 1/48th of a oil well in a corporation. It'll get down to where they'll know everything about everything. And I really enjoy my privacy. I think there's some things the government should know. And this is just, they'll say the old camel's nose under the tent on this one. But I think for us, I think it would do a lot to essentially say that we're going to make sure that people are going through the know your customer within the financial system for the formation of our LLCs. And that essentially crosses the box on probably the best system that we have out there, both privately and in the government, for researching whether or not you have a bad actor. That's essentially the gold standard. And we could get that for relatively a very, very low cost, I think, that would save our reputation from the standpoint of these things. That's just saying that you have to be, have a U.S. Banking interest or a U.S. financial interest that has gone through the know your customer process. And that's a really, really low bar. And if they don't, then it's something that the registered agents, I think, should have everything at the Secretary of State's office, just in case you have a registered agent at some point in time that goes out of business, dies, and they got their laptop there of all their information. What happens with it? So all that should be memorialized at the Secretary of State's office, I believe, for one thing. I don't know whether it is or isn't. It may be already, but I think that we need to check that box and make sure that is memorialized there, and that data is always going to be there. And if somebody doesn't have a U.S. bank account, or if you want to say is a member of that other reporting agency, that does essentially the same thing as know your customer, I would think. Then that's really the gold standard that we could do, and it doesn't cost us hardly anything. And I think it lets everybody know that we're making sure that people are that in our system, basically are going through everything that can be done to make sure that they've been checked out. And frankly, folks, crooks are crooks. They're going to get around the system, so I think that, we can put something forward that doesn't cost us anything, doesn't cost our customers anything, and it's the best you can do. But these people are going to exist. Anything we do here, it's kind of lip service in a way, but we're just trying to protect our reputation.
Okay, very good. Thank you. Thank you, Treasurer. Any other public comment? Is there anyone online? Anybody here? Any general public comment on any items that we've discussed the last couple days? Okay, so I'm going to close public comment. No one else. Okay, so we're going to close public comment and then want to just move now into kind of directives for, for our staff, some work to get ready for our next meeting. And I just want to kind of go down memory lane a little bit, what we talked about yesterday. And I'll ask Mr. Anderson, kind of we've already put a couple things out there for kind of homework to get ready. So why don't you just review that? I think 2 bill drafts.
So, Mr. Chairman, from my notes, I believe from yesterday, you had asked us to go ahead and work with State Board of Equalization on their 3 items. As soon as I think they still have some work to do on those, but as they work at those before our next meeting. So we have that on our list so far. And then the 2 bills from this morning, Mr. Chairman, related to tobacco, the premium cigars, and then the cigarette tax with a blank amount.
Okay, and then so going back to yesterday's topics and then just kind of our management council directives, I'd like to kind of set up some kind of deal where we can garner some proposals, and that's the way the management council topic number 2 for our committee, to identify some options. And I guess we want to, I'll leave it to you guys to kind of start setting up a system where folks can come through the LSO and say, hey, we would like to be on the agenda next meeting to present this to the committee. And I'm not talking about raising taxes, existing taxes, or anything about, hey, this is a new idea for Wyoming. And maybe it's in energy production, or maybe it's in some other, some other industry or whatever that, and maybe it involves, the priority 4 state lands. And maybe those things are all kind of in with that. So I'd like us to just kind of give that as a homework assignment for staff to kind of develop that, report back to us how. And then I think there's probably a way, if we get 50 ideas, there's probably got to be a way to screen them a little bit. Mr. Chairman, somebody has something that would go, that's not, we're not going to drill a hole through the mountain or whatever it might be. So anyway, I guess just a little grace to get moving on that. Is committee all right with that?
Mr. Chairman, I think that's a good approach. I think there might be some things that we want to be more specific about. And I'll, just throw that we talked about yesterday. We know that the issue of the property taxes is out there, and we need to have some folks thinking about that. And maybe we could include the assessors and members that want to work on that. Maybe they could kind of on their own form a working group on that and come back with some property tax proposals. I think that'd be helpful and allow for that subject to develop. I just adamant that it be in conjunction with the Department of Revenue and with the assessors. And that could be informal, actually. It doesn't have to be anything. But on a more formal basis, Mr. Chairman, we did hear about the governmental tax exemptions yesterday. I think in the end, we don't have a specific bill. We had that bill that was a few years ago. But I'd like to propose that we dust that bill off for the next meeting and that we take the section 3 out of it, the poison pill. Because that's, and if any member wants an individual draft on the poison pill, that's great too. But I think that would be a decent thing to have come forward. And we need to get that section 3 out of it because it's just a red flag. And we don't, that would be something we could actually consider. So I don't know if you want a motion on that, Mr. Chairman, but I'll tell you where else I'm going. We had the discussion about the gaming and the gaming issues. I'm loath to leave that alone. So I would propose that maybe we have 2 drafts in the gaming area. One is to follow some of the suggestions that Mr. Downing proposed. I think he had a list, and that was a decent list, and it's more about the regulatory track, and Ms. Wilkinson filed in on that. That would be one bill draft, and if the committee doesn't want to do it, I'd ask for that individually. But the second bill draft in the area is an opt-out provision for counties so that they could, a county could decide they don't want skills-based gambling. But in that opt-out provision, we have to recognize existing operators. So I would have something like a 5-year recognition of the existing operators. So those are some suggestions with some specificity that would allow things to be being developed for our next meeting.
Mr. Chairman, co-chair, I'd like to add one more to that too. I just think we ought to, as the revenue committee, just look at all these streams. You know, we got all these different little gaming components. We have revenue streams going in multiple places. There are reserve accounts too that you don't see. I mean, I want to see those reserve accounts. Why did we set that up again? And how much is in it? And why do we have? So I think we want to look at that whole revenue flow of all those, just to make sure it's, you know, kind of doing what we think it's doing. So I would add that to that. And I think what you're talking about on this first idea, here's what I wrote down. We're really the liquor license piece, maybe a definition of truck stops, smoke shops, you know, the 4 per location, those kind of things, 20% tax, $3.
Like that a lot.
Yeah, all those things were kind of listed yesterday. That's what I have. Is that kind of what you're thinking?
Yeah, yes, sir. I'd say so. We can move it around in different ways, but yes. And then the separate opt-out bill for counties.
Could I comment on
Yeah, go ahead.
that?
Yeah.
So just my opinion, in having sat in on some of the commission meetings, gaming commission, they are working hard to try to stand up the different entities at the request of the legislature. I personally would like to leave them alone for at least 6 months and just get through a session where we don't continue to, with the Scribner's error as an example, totally threw them off track. No fault of their own. And so that's just my opinion. So I would appreciate on that one, rather than just in general, I'd ask for a motion and a vote on that. And I probably will get outvoted, but on that particular piece.
Okay, let's keep discussing here if we can, or if is that all right? And just hold your motion for a bit and then, and I appreciate that. I just want to, anything else that,
so Mr. Chairman,
go ahead.
If I could. So going back to yesterday's discussion, the K through 12 revenue, it seems to me that we had a bill last time, and for some reason, I can't see it, but it was how it basically tipped. And I know tip's not the right word.
Severance tax distribution, yeah.
Should we look at that in relationship to the K through 12? That bill again?
Representative Sweeney, and that's a different issue, which I think is kind of last year's. We could probably take that up later, I think, but this is more about kind of trying to solicit ideas from folks out there. And that might have an idea, maybe not. And so it's kind of a different, but what revenue flows is certainly in our purview. And I think, and that's part of our Directive from Management Council or last year's continuation of the 21 interim topics. So you bet. I think in our next couple of meetings, we got time to consider that. That's a pretty straightforward bill. I mean,
So, Mr. Chairman, the other thing that we had yesterday was it was part of the K-12, but it was also the state lands and the trust. And it seems to me that an obvious gap in the whole state lands issue is in holdings in Teton County, as the lands that we hold in Teton County. And then also a piece of low-hanging fruit. I cannot get past the fact that our private grazing alternatives are among the highest, but our charges for trust lands grazing is among the lowest. I'm having a hard time being happy with that.
and
Well, we are the revenue committee and it is about
where are you
schools.
going with? Yeah.
So could we have how about a bill draft that changes that?
Maybe,
Takes it up to the average in our western states or whatever.
what I was kind of thinking about that thing, and maybe it's just a study bill to start. I think just to study really, and this would be carried on to the in the 67th Revenue Committee to really study all of our leasing. How does it compare to all those western states? Maybe we're way ahead in some areas, and maybe just kind of look at that on how we're doing on that. And because it's a huge, huge asset. And you look at some states that have really taken off. And yeah, absolutely. The Teton County part is a huge part. But I think maybe the first bill is a study bill on some of that. In my mind today, and
I'm good with
in
that.
April. And then maybe when we come back together in September, we have more specific ideas on certain, sections or whatever. Or maybe maybe in the future we come back and, as we created the State Loan Investment Board, that's a legislative creation to oversee those state lands. They were, the legislature was charged with the trust duty, and we set it up the system that we now have. But get really nervous the thought of one of those pieces sold right now for 40, 50 million or whatever number. It wouldn't be enough, And so I think it's a different deal. And maybe we all think about that, how that would roll out. I mean, that would be a classic legislative executive branch issue, but it's so important. And we all have this duty to do. So, but anyway, I don't have anywhere to go with that, but that's maybe in our next meeting. But well, okay, so I've written down about 8, 9 things here. I don't know, and we can do this in 2 ways. We can go down these one by one. Well, first of all, I want to hear Representative Jennings. Go ahead. You've got another one.
Mr. Chairman, so I'd actually 2 or 3 here.
You bet.
From talking to the assessors, I think that this committee passed out the acquisition study bill. I'd like to see us go back and visit that, put that back on again. And then from talking to the assessors, I think there was some interest in lowering some tax rates and to give some relief. And then there also was a question about a cap. And so by the assessors.
How about like a working group, maybe you, Representative Jennings, Representative Gray, Representative Sweeney, you were on that last year. Anybody else that would want to work with the assessors, bring us all these ideas and get the bill drafts kind of working on that. Because I think this is it's going to take a little extra work. Representative Gray.
Yeah, Mr. Chairman, I really appreciate that. We had some good conversations yesterday. I think everybody, last year we had an experience, but I think it moved the ball, and now we're all working on the same wavelength, just talking with the assessors. I think there's really an opportunity here on lowering the assessment value, caps, the constitutional approaches that Senator Dockstetter approach. I mean, we put it all on the table. And, you know, the danger is if we don't do this and then we come back in September, I mean, there's a pretty long lag, and then we're only have 2 months before the November. So I would really appreciate if we could formalize sort of that working group and come back.
Oh, I think that's a good, because this is it's not like, you know, it's not a single kind of issue. There's a lot of moving parts. So you three.
I'd like to be on that group, Mr. Chairman.
Was that Representative James or Senator James? Okay. Who else was worked on that? Did I work on that with you? Can't remember.
Mr. Chairman, I think there has to be kind of a bit of a balance of
Yeah,
interest.
we got one
You know,
senator.
I love the present company that's proposed for it, but you guys all have a kind of come out of the same crucible, if you don't mind. And I have a bit of a different opinion about our ability statutorily to accomplish any kind of a cap or a, you know, I just think for a deferral, it's not constitutional. So that's a piece for me. I definitely would be encouraged to explore constitutional based changes to give tax release. Believe me, I want it more than anybody, but I just don't see anything that was statutory. The Salazar bill from last session, not constitutional, wouldn't have made it, came with its own warning. And so that kind of tax relief statutorily, and we need to be very clear about this messaging, because people out there think that we can pass a bill that gives tax relief. We can't. That is in the Constitution, and we have to change the Constitution together. So we got to be clear about that to people that are thinking about this. So you put some balance on the committee.
So if you three, Senator James, that's 4, we're gonna have the whole committee working on this.
We might.
How about you three right here? How many is that?
That's
And-
6.
And Representative Henderson. That's balanced, I think. That's about a 4-4 deal right there. Okay, so you guys work that, that'll be wonderful. And I think the key is right, what you said, but also I think the property relief programs too are a part of this. And we used to fund it much more robustly. And maybe there's a way to take some of those increases that go right to that program. There's a lot of ways to think about this that, yeah, it's a tough deal. So I think there's a couple ways to help with it, is what I'm saying. And you can help on the front or maybe easily on the back end of this. Representative Sweeney.
Thank you, Mr. Chairman. I'm not happy to work on it. But I just don't want to put the effort in that we did, especially Representative Gray, Representative Jennings, and get to the meeting and it's a Natrona County issue. Because I don't believe it is a Natrona County issue, but maybe with balance on the committee, I
think good co-chairs, I mean, I think that's where it starts. And then we come with and then you don't have that in the end. And I think, so maybe that's something we learned.
Perhaps.
But I think, hey, this work never ends. It's been going on 130 years. It's going to keep going on another 130. So that's just part of it. So we'll keep working on that. Here's what I guess I'd like to do. I'd like to just move all this forward and let our staff go to work on this. Or do you want me to break these up one by one and we go through and vote them up, vote them down? Okay. So with your blessing then, Josh, you've got Dean and Emily, you guys have your marching orders on this and we'll keep working and keep plugging away on this. And then as we come in and develop this agenda for the second meeting. So we'll kind of have two more shots at this and maybe even a third if we have to. If we got to meet again, we'll meet again. We'll schedule a third meeting. So anything else before the committee? Representative Henderson.
It's all kind of related. Thank you, Mr. Chairman. But going back to the co-chairman's comment related to, Teton County and the property tax, there's a real tangible concern across the state with our assessment process relative to the fluctuation of the economy and the market values. And then, what people are in terms of their life situation and what they have to come up with at the time that they get their bill. Because I think we need to, as policymakers, have a way of looking at that and see if there's anything that we can do to work together to mitigate that. I mean, I've thought about a 5-year average calculus where, you sort of temper the fluctuation so that people have a time frame to plan. Some people are in a situation in their life cycle where they don't have a lot of choices. And if you're living in a beautiful county like Teton, I mean, things get out of hand. So how do we help? How do we help that? I think there are opportunities to do that instead of just focusing on simply the one piece of it, like the rate or how it's assessed. So people have been around for a while. They know the background, but I mean, the rate on property taxes hasn't changed since 1989. That doesn't stop the amount that we pay from going up, and we need to do something about that. Because, it's real impact. It's real impact to people and their families. So,
And that's a constitutional change.
yeah,
I mean,
I say, let's get on with it.
Not everything is
Not
constitutional.
all, of it, you're right.
Yeah, so we can create programs where the taxes are still collected, possibly deferred. There is one deferral program on the books. People don't use it. Why don't they use it? I actually, that's a good question to ask. But we have a program that we passed statutory last year for county optional. You can look at other ways to broaden tax relief in a constitutional manner. The underlying taxes still have to flow to the tax receiving entities. You can't grant a holiday for them, but you can find other ways to fund them. Like you could expand the property tax relief program. We just put it in. We're revisiting that. We have $3 million. We hope that'll get us through the biennium, but I don't know that it will. And we're going to find out. Could talk about taking that program and making it much bigger. There are things, those are permitted under the Constitution if we do it right.
Yeah. Go to work on those. And is there anything else that we got a lot of work? And I think the whole idea again of revenue, being on revenue committee. I mean, yes, well, and they all start in the house, the ones that just remember. But the idea is to continue this education piece and for us and for the body. And there might be things like today, we know we're going to vote no on, but we got to keep bringing ideas forward, keep talking about, keep working that. And our two big stools obviously are property and sales tax, and continue to modernize and adapt as things change. And our third stool obviously is severance, federal mineral royalties. And that's as with property, as we've all learned, it's pretty volatile. So Wyoming has a lot of revenue at times, but the volatility piece is scary. And nobody likes to run their house like that, and certainly provide the services that we're required to provide. So we just got to keep working it. So appreciate everybody's work. And Representative Sweeney, you have another comment? Go ahead.
Yes. So if I'm going to stomach through governmental property again, and taking a look at the Gaming Commission again, I would respectfully request, as we're looking at the potential of Medicaid expansion, could we possibly ask the Department of Health, and unfortunately I didn't do this, but asking the Department of Health, the 2019 report that they gave the Revenue Committee back then, if that could possibly be further updated and looked at with the matrix they had used then, and try to bring that up to date, so that we might be able to have some better information for one of our next meetings.
I think Representative Sweeney, as we develop the agenda for the next meeting, staff will work all that. Well, as we, that's kind of under that continuation of 21 interim topics. And as we work through that, I don't think that'd be any problem.
So, Mr. Chairman, to add on to that just slightly, would it be appropriate for us to ask with a letter to the Department of Health
Sure, I don't.
to re-tabulate that study? Is that what you're suggesting?
I think we're gearing up for a comment from staff here.
Okay.
Mr. Tempty?
Mr. Chairman, the bill was drafted for Medicaid expansion for this past 2022 session. And the reason the fiscal note took a while is because the Department of Health did exactly that. They updated that 2019. So it was updated just before the 2022 session. So I think it's pretty recent.
Okay, so that shouldn't be a problem then, as we move forward. Okay, and as we develop the agenda and the presentation and all, okay. Representative Yen.
Thank you, Mr. Chairman. I just want to briefly chime in on the property tax issue that article. Oh, thank you, Mr. Chairman. I just wanted to chime in briefly on the property tax issue. There's a Cowboy State Daily article today on the rising property values in Teton County. The way that property tax is structured today is unfortunately gutting our entire community. So I'm glad that the Revenue Committee is taking a look at it. What I'm interested in is seeing, because the community in Teton County, it is a demographic that is buying their second home in Teton County, and then the demographic that is trying to live, work, and retire in Teton County and raise their family. And so what I understand that there is constitutional issues with certain things. So I think I would like to bring forth a constitutional amendment at our next meeting to implement some sort of homestead exemption where primary homeowners can have different tax values than second homeowners.
And since you're on that working group, I think that can be part of that work. And one of my calls was from a person in Casper, actually a week ago, and same thing. His said, why can't we just, if you're 65 and lived in your house for 30 years,
Write it out.
freeze that baby. You've obviously been here a long time. And so I think all those things are worth, or we got to discuss. So keep working it. So appreciate it. You're on that working group. So you guys work on it. Okay. Anything else before the committee? Everybody safe travels home. And as we travel across wonderful Wyoming. Thank you all for being here. And again, thanks to our staff and everybody, Teton or the Fremont County 1 School District for hosting us. A good co-chairman in his hometown here, his old junior high. Appreciate all the work you did to get this agenda ready, and appreciate everybody. So we'll see you down the road sometime in September. And as always, you can always get a hold of us. We're on the LSO on the legislative website. So thank you very much. And the meeting is adjourned.
There's still time to get a cheese wheel on